Good afternoon, good afternoon, good afternoon. It's a take two after some tech issues on Tuesday, July 30th. So sometimes there are tech issues and they are just too much. So we have dealt with some tech issues. We are dealing with some tech issues. We are back for the part two so we can finish up all of the legal that we are talking about. So for those of you that were in the part one, don't worry, it will be back up after we clip out those tech issues, but I didn't want anyone to get stuck in part one when we started part two and be in the wrong chat. So don't worry, part one will be back. It will just be back later because we are going to, fix it in post. Live streaming is dynamic. We'll just fix it in post. Look, here's what we're going to do. We're just going to do like a Wayne's World, like doodle-doo, doodle-doo, doodle-doo. We are here. You have not missed much. We are going to start with talking about Carrie Morrissey's response to Hannah Gutierrez Reed's motion for new trial. The court has kicked it back down, and then we will get into Tik Tok Psychic coverage. So don't worry, we are back. There is nothing worse than out of sync video and terrible sound. We are looking for other solutions. It's just so frustrating. But we're here and it's fine. And we're going to make it fine and we're back and it's all good. So for those of you that are like, what in the world even happened? Don't worry about it. We'll be back with part one later after we make it a little bit of a smoother experience. And we are going to try this again, but I'm going to give you a quick road so far catch up and we are going to, let me see, I need to duplicate. There we go. We're going to give you a road so far catch up so that if you are just watching this stream, you aren't behind on anything. And remember, this is a great time for me to remind you that we have a Quick Bits channel. The Quick Bits channel has not only new content on Monday in the Quick Bits podcast, but it also has clipped down shorter versions of the stream by topic. So if you're just like, I don't need to hear every single thing about Logan Paul getting sued by the US Olympic Paralympic Committee, but I want to hear a little bit, then those are all on the Quick Bits channel, and those are all the those are on the Quick Bits channel, and those are all sent to you in your app. So if you just want to watch them, they're in your app. And if you're like, I don't know which channel I'm on, don't worry about it. If you have the Law Nerd app, you can just click through and it'll take you to where it is to watch. And that's all you need to know. So new app notifications will be going out. So you'll be getting those soon too. And here we go. So for everybody's like, I thought we weren't talking about the Olympics. Now is your moment. Now is your moment. We're just going to talk all about the stream things, and we'll probably do another members only text stream. Don't worry. It just is what it is. We had it fixed and then it wasn't. And look, for those of you that are into astrology in any way at all of my signs are earth signs. The thing that I value almost most in the world is stability. So having the instability with StreamYard since the sale is making me crazy. So when we find a good solution, trust me, I will let you know. We have tried to make this solution work, but when the founders also left after the sale of the company, it has just been very, very frustrated. So not having stability frustrates me, and I apologize to you. And you guys are like, just so incredibly kind. You're like, we know, but it is frustrating for me, and I know it's frustrating for you. And life is frustrating enough. We just need this to be a smooth experience. I mean, this is why when people are like, I'm terrified of live streaming, it's like, if you have a great chat, it doesn't matter. You can roll through literally anything and everything. It's just the kind of community you create. And streamers who just scream at their community all the time get screamed at back. But we bring you all into the process. And here's the thing I've loved. Not Olympics chat, also Olympics chat. It's not that you're never going to stumble, right? It's not that things are going to be perfect. It's how you deal with it from there, because everyone's human, mistakes happen. And, even divers flop sometimes, gymnasts fall. It just happens, and it happens to all of us, and it happens all of the time. So we just remind ourselves that nothing is perfect, even though we would like it to be, and we keep rolling. Because it is what it is. Let's talk Rust, and then we're going to talk Tik Tok Psychic. But we had briefly covered the fact that the Court of Appeals is allowing Hannah Gutierrez's motion essentially for new trial, or motion for immediate release. It's also asking for a new trial. It's also asking for the case to be dismissed, to be heard by Judge Summer at the trial court level. Hannah Gutierrez has already filed a notice of appeal. And when we had tech issues strike, we were just getting into the response from the state. Yes, Carrie Morrissey is still the prosecutor handling these motions for the state. When a date is set for these motions, we are going to be covering it live. There is no way I'm going to miss that. There is not a chance we are going to miss it. We are going to be covering this live when it comes up. So the appellate court said, yes, the trial court level can hear this motion, essentially this motion for new trial based on new evidence. And the new evidence in that the defense is alleging is the failure essentially to turn over reports. They didn't lean as much into the grounds that Baldwin leaned into. Why? Because they knew that. They already knew those things. So this is leaning in a different way. And with that, we're going to pull this up again and hope that it all goes well. We started into this motion. It is way snarkier than I anticipated. I am frankly really surprised that there is no contrition, just no contrition at all. It is just snarky. Carrie Morrissey threw Baldwin under the bus, threw Attorney Bowles under the bus, and just like can't stop, won't stop. Can't stop, won't stop at all. It is absolutely a wild choice, but it is a choice. A wild one, but it's a choice. So with that, we're going to get back into this. Hopefully sharing screens does not cause complete tech meltdown this time like it did last time. I see all the chat saying hello to Runkle. Hello to Runkle. We are going through, well, the snark. The snark. It's so much snark. So we had gone through the first couple paragraphs, but look, ultimately, this is talking about Hannah Gutierrez. Ultimately, she loaded a live round into Alec Baldwin's real prop gun, and he proceeded to break virtually every rule related to safe gun handling by actors on movie sets, resulting in the tragic death of Helena Hutchins. Just so the lack of awareness that this is not the judge to start snarking about Baldwin in front of. This is going back in front of the judge that yeeted the case against Baldwin because of Morrissey's actions. And she's going to snark in these motions. If I am reading this as the judge, I am rolling my eyes so far back into my head, I would be annoyed. I can't imagine Judge Summer reading this and taking this well. This is not a well taken point. It said the defendant initially filed a motion for new trial and release prior to her sentencing on March 15th. It was denied April 1st. Then filed a motion for release pending appeal on May 7th. The state filed a response May 27th. The defendant never filed a reply and waited 2 weeks to file the notice of completion. So now Morrissey is snarking that the defense has not followed proper procedure and that there are multiple motions pending for the same thing. She goes on to say on June 27th, defendant filed another motion for release, even though the May 7th motion is still pending and has never been heard on its merits due to defendant's failure to follow the simple procedure. Tell me more about following procedure. Tell me more about following procedure. Tell me more about following procedure. After an entire case got dismissed for someone not following procedure. Like, okay. Carrie Morrissey says she is now responding to defendant's third motion for release since her conviction on May 6th. The motion for release filed on June 27th is a motion for release in anticipation of a motion for new trial. The motion for new trial was not filed until July 16th. And the undersigned counsel will file her response to the motion for new trial by the close of business July 31st. The proper way for a defendant to bring her concerns before the court. Tell me more about the proper way to do things again. The proper way for a defendant to bring her concerns before the court is to file a motion for new trial. And if the motion is granted, then the issue of defendant's condition of release will be ripe for a decision. Undersigned counsel is now responding to a motion for release pending the outcome of a motion for new trial that has not yet been decided by the court. Undisclosed Hag report. We've now just jumped into a whole nother topic. This is just, Your Honor, he's not following the rules. Okay, Carrie, sure. Undisclosed Hag report. In her June 27th motion for release in anticipation of her motion for new trial, defendant alleged that she has been prejudiced by the state's failure to provide her and her counsel with copies of 2 reports from the state's ballistic experts, Lucian Hegg. True. That's a good summary of where we're at. Defense counsel is either intentionally misleading the court or simply has not done his homework. Ma'am. Or simply has not done his homework with regard to allegations against the state. Hagg produced 3 reports. The first was issued August 2nd, 2023, and was timely produced to defendant. The second report was produced August 31st. Undersigned counsel believed she had forwarded the report on to defense counsel, but realized during the pretrial work on the Baldwin case that she had inadvertently failed to disclose the report. The third report was produced on October 5th and was disclosed to defense counsel and also uploaded to the discovery server for Ms. Gutierrez. So the second report was produced August 31st. You're using produced in a very confusing way, because produced can mean given to defense. Produced can also mean that it was written by the expert then. So I think her use of produced here is misleading. Also, just a reminder for all of you watching the Olympics, I also want to be watching the Olympics, but I also want to stream with you when I normally stream. So thank you for no spoilers, because I cannot watch the Olympics and read motions at the same time. So I appreciate it, because otherwise it very much hurts my heart, because I will be staying off of social until I get to watch the Olympics later today. Thank you. I appreciate it. Thank you. It's something I enjoy, and I appreciate the no spoilers. So, and I appreciate to the mods who are deleting them in the chat. So thank you. Let's see. Olympic spoilers. Somebody did something athletic and impressive. Thank you. So she's using produced in a very confusing way. The second report was produced on August 31st. Okay, the second report was written on October 31st. The undersigned counsel believes she had forwarded. Okay, your belief is not relevant to whether the defense got it or not. And this was the issue in Baldwin. Believes she had forwarded the report on to defense counsel, but realized during pretrial work on the Baldwin case, she had inadvertently failed to disclose the report. Your intent is irrelevant. I had to say this a million times when we were talking about CoffeeZilla Logan Paul. Like, Logan Paul's like, I didn't intend to do a thing. Okay, but the thing happened. It's the same with Carrie. Intent doesn't matter to whether it's a violation or not. I intended to turn it over. Okay, but did you or did you not? The not turning it over is what matters here. So this is really narrowly parsed, isn't it? The second report, it seems, was written August 31st, 2023. Counsel believed she had forwarded it to defense, but realized during the pretrial work on Baldwin that she failed to disclose the report. She said on the stand she knew that was a Brady violation. The third report was produced on October 5th and was disclosed to defense counsel and was also uploaded to the discovery server for Ms. Gutierrez. See Exhibit 1. The state concedes that it failed to disclose the August 31st report, but disclosed the October 5th report the same day the state's counsel received it. Right. When did the August 31st report ever get turned over, though? The only report that was produced by Hag that was not disclosed was the August 31st report discussing the tool marks on the top of the sear. Isn't that the problem, though? Isn't that exactly the report that's the problem, though? Because that report shifts what the defense might have asked. That report shifts whether or not the gun was an intervening cause and whether or not the gun was not acting properly in a way that Hannah might not have known. Yes, it's Hannah's job to maintain the guns. Yes, this is different than Baldwin. Yes, she should have known if the gun was not working properly. But it's something the defense could have argued if they had had that report. So when was it produced to the defense? When was it turned over to the defense? If ever. So they say the only report that was not disclosed was this August 31st report. Should have been disclosed. Still going to be a problem. Remember, though, the standard for after trial is different than the standard that Baldwin had. New Mexico has actually some fairly defense-friendly standards. The defendant doesn't have to meet some of the burdens for violations impacting them the way they do in other jurisdictions. But that shifts after trial. It is a higher standard to meet for the defense to prove that this matters after trial. But it's still an issue, and you still get to have a hearing about it. Bowles was acutely aware of Baldwin's claim that the gun discharge absent a trigger pull. Emily, no, we're not in the pool. Pull. And was also acutely aware of Baldwin's counsel's absurd assertion that the gun was modified by someone and the unproven modification resulted in the gun going off by itself. Okay. It is worth noting that the most likely person who could have modified the gun was Miss Gutierrez. Your point is lost in the shade. It's lost by the shadiness. The court isn't going to like this at all. The court isn't going to like this at all. In State's Exhibit 2, Bowles verbally attacked undersigned counsel for dismissing the case against Mr. Baldwin and requesting forensic testing of the gun in response to Baldwin's counsel's claim that the gun was modified. Well, I'm interested to see that. Bowles stated, quote, when the slight wear and tear in the newest report, quote, not sure which report Bowles is referring to, isn't remotely evidence of modification or anything to do with the trigger function or functionality of the weapon. You have videos showing the gun properly worked, cocked, and fired on set, and the FBI said that the gun functioned properly prior to their damaging it. Baldwin had to have pulled the trigger, and you know it. Right. If the sear, Bowles is likely referring to the hammer and not the sear, notches were filed down, it wouldn't have, quote unquote, cocked. So Bowles is yelling at Carrie saying, you shouldn't be dismissing the case. Michael, it's good to see you. Also, thank you for the gift of memberships. This is before. So they're talking about the first dismissal of the Baldwin case, not the second dismissal. This email is regarding the first dismissal. The Baldwin indictment was originally dismissed, Carrie says at the request of defense, while the FBI testing was underway of the weapon, and then it was re-indicted against him, and then it was dismissed with prejudice. So they're talking about dismissal 1. Hopefully that helps clear that up. But it sounds like Bowles is saying, Baldwin's trying to throw my client under the bus. Fuck that shit. You know that the gun was working properly because everybody said so. But if he didn't have the report in his hand that contradicted that, he might have changed his position. Or he might have changed his position after that mutual defense agreement with Baldwin's attorneys. Who knows? It's his right to do so. He's the defense attorney. It goes on to say, it is important to note that Gutierrez hired her own quote unquote expert, Frank Cocky? How are we pronouncing Koucky? I'm going with cocky. The nice man who pointed, oh, Jesus Christ. Carrie, this is so wild. This is wild. The nice man who pointed the gun at the bench during his testimony in Miss Gutierrez's trial. Oh my God. That's right. I remember that. But Carrie, what is this? What is this? Oh my goodness. This is my child calling me for a second time. Chat, I apologize. Give me 30 seconds and let me see what he needs. Sorry, chat. It is like streaming parenting is also dynamic. Hi. Today's just going to be a day. The nice man who pointed the gun at the judge. Remember, Your Honor? Remember? He pointed a gun at you. Carrie's as the court can see from State's Exhibit 3, undersigned counsel offered to have the gun made available for Mr. Cocky? For Mr. K's inspection and testing, for Mr. Gunpointer, for Mr. K's inspection and testing, and Bowles never took steps to have the gun tested or examined by the expert. He was not great. Like, he is not great. He was amusing, but he was not a great expert at all. He was just not a great expert. The photo of the previously unexplained, quote, now explained unusual tool marks on the working surface of the sear was in the possession of Mr. Bowles, and it was his duty to provide those photos to his expert for review as the defendant's expert. The tool marks referred to in the August 31st, 2023 report are clearly depicted in the photos that were in possession of the defense long before Gutierrez's trial. It doesn't matter. There's another report that can be cross-examination. Like, there's lots of things. Mr. Bowles has misrepresented the August 31st report to the court in his motion. The report clearly states as follows. I mean, just attach the report. Just attach all the reports at this point. Let's see. Microscopic images of the sear engaging surface from the Santa Fe Sheriff's Office, item 1, evidence revolver compared to the FSC exemplar sear clearly clarify the differences in tool marks observed on the items. As can be seen in this figure, the exemplar sear possesses consistent parallel tool marks from the machining process, while the Sheriff's Office item 1 evidence sear possesses coarse, irregular, off-axis, and diagonal tool marks. I mean, they do look different. Yeah. Let's see. Off-axis diagonal tool marks of an unknown origin. It seems unlikely, although it cannot be excluded, that these tool marks are the result of the damage incurred during the FBI's impact testing, because the access of these striae are not aligned in the direction that the hammer would have engaged and applied pressure to the sear. While the tool marks observed, she's highlighting the parts that he left out in his motion. So that's okay. So let's see. Sorry, guys. All right. So she's highlighting the parts that Bowles didn't discuss, but she still can cross-examine on this. It says, while the tool marks observed on the working surface and front surface of the Baldwin gun, which is the item 1, do not appear to be original manufacturing marks or use and abuse tool marks based on any based on the striae's irregular orientation. These tool marks are also unlikely to have had any bearing on the operation of the revolver at the time of the incident, based on the FBI's trigger pull data, an FBI photograph of the hammer and full cock, and substantial test fire of item evidence 1 conducted by the FBI prior to the damage of the trigger, sear, and hammer. The initial testing documented a lack of malfunctions, and their measured trigger pull values are consistent with the numerous other evidence and exemplar revolvers. So they're saying, she's saying essentially this isn't going to meet the burden that it would have changed anything. So the burden is going to be different for the hurdle Bowles has to cross to show that this would have influenced the jury, that this would have changed things. This might not have changed things. That's what she's trying to argue, that this isn't going to change anything. But the defense is arguing we would have or could have chosen to cross-examine on this, but you can't make that choice if you don't have the report. The defense might not have ever used this report, because this might actually hurt Hannah's case that she was doing her job. Because if something was malfunctioning with the weapon, it's her responsibility. Different than Baldwin, right? Baldwin's argument on this report would be, see, Hannah wasn't doing her job. Nobody was doing her job. So Baldwin's story that the gun went off is not implausible. Something was up with the gun and it's not on him. So the argument to Baldwin is very different. Very, very different than the argument as to Hannah. Because again, if she doesn't know that the gun's malfunctioning, then that's still on her, and that's still her not doing her job. So this is going to be harder for her to overcome, right? Let's see. It goes on to say, Hagg's report simply noted the unusual tool marks, and he continued to opine that the gun worked properly. You still get to have that report, though. You still have to turn over that report, though. It goes on to say, as this court is aware, as this court is aware, Hagg has since received additional information regarding the history of the gun and the accidental discharge testing of the gun by Mr. Ziegler at the FBI. Yes. The FBI! As a result of this additional information, he modified his opinion in the August 31st report. Mr. Hagg conducted a second pretrial interview with Mr. Baldwin's counsel on June 19th, wherein he stated as follows. I would say in retrospect, since I have both the benefit of seeing Mr. Pieda's interview as to how he makes the firearms, and the interview fairly recently with Bryce Ziegler, where it could clarify how he did the impact testing, I would say my statement back in August was perhaps premature. So this is Hagg's interview on June 19th regarding the August 31st report from the year prior. I would say my statement back in August was perhaps premature. I still maintain this is obvious damage, not an effort to improve the trigger in some way. It's not something that came in the gun, but what I didn't know at the time was the history of the gun. So the statement was a very neutral. I don't have any further information. Now I do. I've learned that the particular gun was The industry often calls it a one-off gun. It was assembled especially for a thing I usually attend. It was assembled especially for a thing I usually attended until a few years ago called The Shot. It is that's an uppercase SHOT show. This is a trade show that goes on for 3 or 4 days. It's generally only open to federal firearms dealers. I have a federal firearms license to show new products. So there's one source, highly unlikely because they're all professionals, that the hammer would still be in the gun at the SHOT show. The firing pin would have been removed, but again, you don't need to take the hammer out to do that. But I didn't know in August where this gun had been. So now I know it went to EMF, the distributor. Pieta said in his interview this is back in May, I believe, that he personally assembled the gun. It went to an Italian proof house. That's an added point to be made. This is an organization that looks at the workings of the gun and whether it will withstand pressures. So it's been to the SHOT show. That's one choice. The other choice left to us is the aggressive testing. Oh, the choice of how things happened. The only other choice left to us is the aggressive testing at the very end of Bryce Ziegler's work on the gun. The FBI! So that is the only reasonable and logical explanation. And insofar as Mr. Ziegler, that helped because in August, I didn't have a real clear understanding. Why does this matter? I didn't have a real clear understanding. I didn't feel it was appropriate for me to call him up as a witness and ask him about his testing, but he's described in some detail. It clearly offers an explanation not only for this, several times now, the aggressive tool marks, but the diagonal aspect. All of this happened after the trial. All of this happened after the trial. So none of this really helps. I don't even know if they had the Pieta interview done before Hannah went to trial. So this is after. It goes on to say he used we probably all know this much. He used some sort of rawhide mallet. Yes. We know that the FBI beat off the cock notch. We know. We heard all about it. The gun was mounted in a fixture. That makes perfect sense. I have a similar fixture, but the blows that he gave to it, while he was beating off the gun, the blows that he gave to it with a rawhide mallet, and it was not necessarily in any sort of apparatus that would deliver the blow in a perfect back to front. It's getting worse. I'm going to illustrate. Great. Illustrate the back to front blows that were given to it by the FBI. Sure. Sure. But I'm going to illustrate. So here's my Pieta. This would be mounted in a fixture, and you have the choice of coming perfectly straight on. That would produce shear marks that go perfectly front to back. But if you came in at a slight angle, if it's angled, if you came in at a slight angle, it's going to apply a side force. So that could be right to left or right to left or left to right. And that could and would easily explain not only the damage, but also why it's got an angular component. Well, which way it gets blown and whether it's back to front, whether you keep your skis on and what happens to the cock notch is all very important. But this is after Hannah's trial. So none of this is in his report. Oh, gosh. Ms. Gutierrez was charged and convicted of using a firearm in a negligent manner and or loading live ammunition in the real prop gun and failing to perform an adequate safety check of the ammunition as required. Even if we assume that the Hague report stands for the notion that the gun fired by itself or malfunctioned, which it does not, I agree with that. It does not change the facts and circumstances that surround Gutierrez's conduct that resulted in her conviction. And that's part of the difficulty here on this motion for Hannah. It's not as clear and easy as it is for Baldwin. I think her lawyer would like it to be, but it's not going to be as easy. I appreciate that we're going to get to the law so we can talk about the difference in standard as we get there. But this motion is really like, can we just she wants to get out of custody, but she kind of combined all the things into one. Mana, I hope I said that correctly, said, we all just went from adulting to 10th grade giggles. Yes, because the law can be funny. And when it makes dick jokes, I am always going to laugh. So, yes. But I think, again, this judge was really, really upset with Prosecutor Morrissey or Special Prosecutor Morrissey. I don't think the snark is helpful. I think this kind of clear, but Your Honor, this is the full circumstance, is much more helpful than the snark. So it goes on to say that Hagg modified his opinion after receiving additional information about the gun and the accidental discharge testing, and has now opined that the unusual tool marks referenced in the August report were the result of the FBI's accidental discharge testing, not the FBI with the accidental discharge. Mr. Hagg did not perjure himself during the testimony at Gutierrez's trial, and undersigned counsel did not suborn perjury. Mr. Hagg was asked questions by Mr. Bowles related to the functionality of the gun and answered all those questions truthfully. Hagg's testimony regarding the lack of damage or modification of the gun was accurate given the context of the question from Mr. Bowles, which centered around the functionality of the gun and whether the gun malfunctioned. See Exhibit 4. I'm looking forward to Exhibit 4. I'm ready. Law governing post-conviction release of defendant. Are we going to get to the law for the motion to dismiss? Maybe not. This is 5-402C. Release after sentencing. After imposition of a judgment and sentence, the court on a motion of the defendant may establish conditions of release pending appeal or a motion for new trial. The court may utilize the criteria in 5-401 and may also consider the fact of the defendant's conviction and length of sentence. The defendant shall be detained unless the district court, after a hearing, determines the defendant is not likely to flee and does not pose a danger to the safety of any other person or the community if released. So is the factor they're worried about fleeing? Because do you guys think Hannah Gutierrez is a danger to the community? I don't think that that's the worry here. So let's see. The factors to be considered in determining conditions of release. In determining the least restrictive conditions of release that will reasonably ensure the appearance of the defendant and reduce the safety risk to the community are as follows. The nature and circumstances of the offense charged, including whether the offense is a crime of violence or involves alcohol or drugs, the weight of the evidence against the defendant, which is going to come up, right? The weight of the evidence will come up. History of the defendant, including character, physical and mental condition, family ties, employment, past and present residences. So that's all going to a person's stability. Like, are they stable? And then what other behavior do they engage in? Subsection B is whether at the time of the current offense or arrest, the defendant was on probation or parole or other release. That's not the case here. The nature and seriousness of the danger of any person or the community that would be posed. I don't think they're going to, maybe, I don't know what this prosecutor will do, but arguing that Hannah's a danger would be odd. I think arguing that she has every reason to run is a larger argument here, because that would be the only argument, is that she won't come back if she has to go back into custody after all of this. Let's see. Any other facts indicating the defendant may or may not be likely to appear as required. And that might be how she feels about the case from her jail calls. I don't know if that'll be persuasive. Any other facts tending to indicate the defendant may or may not commit new crimes. I think it would be hard to argue that there's anything to say that there's any evidence that she would do this again. Like, she's not going to have an armorer job that she does badly in her time of release. She's not going to have an armorer job again, ever. It goes on to say, while Gutierrez has no prior felony convictions, she does have another felony case pending. The history of her time in New Mexico is troubling. Okay. Gutierrez was only present in New Mexico for less than 4 weeks, and there's evidence she committed 3 felony offenses during that time. What are the 3? Gutierrez has been found guilty of involuntary manslaughter. She has a pending case for carrying a firearm into a liquor establishment. That's going to be a problem. which appears to have been committed with blatant and flagrant disregard for the laws related to public safety. There is ample evidence that Gutierrez was in possession of cocaine. I don't know if ample's the word you want. While in New Mexico handling firearms daily. But the jail calls. Okay. As evidenced by Gutierrez's cellular extraction, Gutierrez has a significant substance abuse problem that dates back nearly 10 years. Her cell extraction contained evidence of long-term alcohol abuse, cocaine abuse, and psychedelic mushrooms, and evidence of huffing from aerosol-type containers. Like, how recently, though? I mean, we definitely have some evidence of bad decision-making. So, while incarcerated Gutierrez, the jail calls, I think, are the most damning, honestly. While incarcerated Gutierrez's jail calls indicate previously undiscovered violations of her conditions of release prior to and during her trial for alcohol use / abuse to such a degree that it appeared to have negatively impacted her personal relationships. I think that is probably more of a factor that the court's going to consider strongly. The admitting to violating terms of release prior to and during trial is not good. Is not good at all. Greedy Gambler said, I didn't hear any of the jail calls. Did I miss something? We don't have audio of the jail calls. We have the recitation of the jail calls, and we read through those in the breakdown of the sentencing memorandum. So the jail calls indicate previously undiscovered violations of her conditions of release prior to and during trial, impacting personal relationships. In 2 jail calls, Gutierrez discusses consumption of alcohol while on conditions of release, and her boyfriend complained that she mistreated him when she consumed alcohol. She has no significant family or community ties to New Mexico. I mean, yeah, she's not from, she's not from here. While incarcerated, Gutierrez's jail calls indicate a clear disdain for the court's orders and a willingness to refuse to appear in court while ordered. That is more relevant than some of the stuff found on her cell phone to me. The willingness to flout court orders and the discussion of the court and not doing what the court says is stronger, and I think is a much stronger argument to the court. Your Honor, she's already saying she doesn't give a fuck what you say. I mean, then again, Carrie. We're in such a weird spot after Carrie testified, and now we're reading these motions. It's just such a different perspective now than it was before. But in one phone call, Gutierrez expressed a willingness to refuse to appear to Baldwin's trial, even if lawfully subpoenaed. That. All of Gutierrez's family members and her boyfriend are gun owners, and Miss Gutierrez expresses a willingness in her jail calls to run afoul of any court orders requiring her to refrain from possessing firearms. That's true. She was discussing how she'd get around those rulings. In one phone call, she discussed with her boyfriend that he could put his guns in a safe and can tell them, probation, that she doesn't know the combo. Conclusion. The defendant's motion for release is premature, given the court has yet to receive complete briefing on the motion for new trial, hear arguments on defendant's motion, and rule on defendant's motion in defendant's favor. So she's saying, no, don't release her. No, this is all premature. All of this should be ignored. This is still coming from Carrie Morrissey as special prosecutor for the 1st Judicial District. Let's take a look at these emails, shall we? Let's just go to that. All right. This is from October 5th, 2023. Let's see. Luke, did you get a chance to write an addendum of your report regarding the additional testing at the Sheriff's Department? I can't seem to find one. Thanks. Yep, attached as PDF. Excuse me. We'll be sending this. Will I be seeing this soon on national TV? Oh, that's snarky. Well, there had been insinuation that Carrie had been leaking things to television. So this is from October 5th, 2023. Will I be seeing this soon on national TV? Luke, P.S. The 2 demos are too large to send together. They will come one at a time moments from now. Okay. States Exhibit 1. This is from Jason Bowles to Carrie Morrissey, CC'd Bullion, Bowles. This is, let's see, what date is this? June 16th, 2023 at 5:03. Par for the course. Well, I need the rest of the email. Damn it. Par for the course. Interesting, though, that you were able to accept Baldwin's unsupported theory and null pros is what he's talking about. And null pros, which is the dismissal, when you didn't have to get the New York lawyers out, when the slight wear and tear in the newest report isn't remotely evidence of a modification or anything to do with trigger function or functionality of the weapon. This goes to whether it impacts the defense at all, but you still have to turn over the report. But this is all getting into the motion for new trial. So Carrie Morrissey's part arguing the release and part arguing the new trial, while arguing that the release is premature and arguing that the new trial hasn't come before the court yet. But she's including things in here for both. And that's why she's using this opportunity, I think, my opinion, to just throw Bowles under the bus and be like, your argument's disingenuous because you said this was bullshit and you yelled at me, because that's what she said in her motion. You yelled at me for all of this. So he's saying you null prost dismissed Baldwin's first indictment to get rid of the New York lawyers based on the slight wear and tear, even though it's not remotely evidence of modification or anything to do with trigger function or functionality of the weapon. You have videos showing the gun properly working, cocked and fired on set, and the FBI said that the gun fired properly prior to their damaging it. Baldwin had to have pulled the trigger, and you know it. Is that why Carrie put this in here? Is that why she put it in here? Because I feel like that's why this is in here. Baldwin had to have pulled the trigger, and you know it. If the sear notches were filed down, it wouldn't have even cocked. I wish you had applied the same rigor or lack thereof, even-handedly, to both defendants. The rich A-list actor gets an overly deferential review and dismissal, and the young female arborer starting her career gets scapegoated. You spent 3 hours with Baldwin's lawyers and never even bothered to interview our expert or witnesses we lined up. If you think this is justice, so be it. It isn't consistent with the prosecutorial function. It isn't consistent with the prosecutorial function, though, and I've been what? Bowles, no. And I've been a prosecutor and in that position, so I can speak with authority on it. Sir. Bowles. Bowles reminds me of all of these defense attorneys that used to come into court, mostly DUI attorneys in the high volume misdemeanor courts, that would come in and be like, I was a DA. I've been in your shoes. And it's like, bitch, you were in the office for 6 months and then you left to go do defense work. Shut up. Like, how long were you a prosecutor for, Bowles? And also stop it. Oh God. There's always the, I was a prosecutor every single time. Sir, I need to know how long Bowles was a prosecutor for. But again, I think some of this is being thrown in there to absolutely shade Baldwin. But again, she's kind of arguing a little bit of both motions. She's arguing that the motion to release Hannah Gutierrez is premature. And she's arguing, look, Your Honor, she's kind of laying the groundwork for, even though this report we acknowledge wasn't turned over, it doesn't matter because that wasn't the defense's theory. That wasn't what the defense was arguing. And it's worse for the defense if Hannah hadn't caught that the gun was not working properly, because that was her job. So she's laying the groundwork for all of it, but only arguing really the motion for immediate release. Let's see. The colors of this email thread at least make it clear what's happening. Ooh, there's a transcript. I can't wait. Let's see. we're going to try to go in chronological order. This is starting on April 4th at 7:53 p.m. Let's see. All right. April 24th, 2023, 7:57 p.m. I'm just going to say, lawyers, all email programs now allow you to just send emails during work hours. Even if you're writing them, I just need the profession as a whole to like stop working 24/7. It makes all of you cranky and imbalanced. None of you are healthy, happy individuals. Rainbow 910 said, Emily, I remember in 2020 you saying, how do you know a defense lawyer used to be a prosecutor? Don't worry, they'll tell you. And it's been true ever since. It remains true. It will always be true. It's kind of like when people first get into CrossFit or anything. Like they'll tell, like the people that just get into CrossFit will tell you that they're into CrossFit. Same. They will absolutely tell you. All right, Carrie, this guy, but let me see if I can embiggen. Oh, that's better. But I don't mind. Like, what email program is making these all colorful? I'm here for it. It makes it so much easier to read the email thread I'm living. Carrie, this guy above is our gun expert, and he is really good. And he is also willing to talk to you and give you background and questions on the gun, and no strings attached to any of it. I mean, there's always strings attached to any of it when you're talking to an expert. This is work. He thinks Luke and Mike are great and very reputable. I'm on the phone with him now, and if nothing else, could give you a 30-minute to 1 hour primer on that particular firearm. He ordered the exact match of the firearm. He has some excellent questions regarding the firearm and functionality and the questions that have arisen. So Bowles is mad that Carrie never talked to his expert. I told you to talk to my expert and you didn't. All right. April 24th at 9:21 p.m. Can we do work during work hours? Folks, all of you would be better balanced. Jason, I appreciate the offer, but I don't need a primer on that firearm. We already had that from Mr. Haig, who also owns the same firearm. Is there any particular testing you want Mr. Haig to do while he has the gun for testing? Just let me know. Thanks, Carrie. All right. That was at April 24th at 9:21 p.m. April 25th at 9:31 a.m. from Bowles. Carrie, I am requesting that our expert be allowed to present and observe, subject to your schedule, of course. Observe what? And present? I'm so confused. Can you just speak plainly? I am requesting that our expert be allowed to present and observe, subject to your schedule, of course. And here is what he is saying. First, the pressure required now to pull back the hammer versus my exact replica on the firearm. If the gun is not now too broken, this, oh my God, this email makes me want to fucking scream. If the gun is not now too broken, this will see if the hammer spring is lightened. Then a careful examination for all function listed on the detail function list I sent you from the auction house. I can resend it. Much of that may not be able to test if broken. The examination for visible wear on bulging, such as trigger, hammer, cylinder, grip, and holster wear, plus evidence of wear on grip, cylinder, and inside barrel. What are you asking for? Cylinder and trigger and hammer should be moved from side to side to check wear and tightness. At least we got this far without wiggling it side to side to check for tightness. Next, disassemble the gun and photograph interior parts up close to show particularly the damage. Is this what he's asking to do? Next, disassemble the gun and photograph interior parts up close to show particularly the damage to Sears cylinder stop that the FBI says they did. Wasn't that already done? Any additional wear or evidence of neglect should be noted. Any interior parts such as hammer, trigger, and springs should be examined to determine if they are original parts or modified in any way from the original. The main question. That is 900 fucking questions. I don't even know what he's asking for. Frank said over a big Colt test series, I quote, that Mike should try to replicate before disassembly. He could also put in a new sear and cylinder stop easily to repair the FBI damage to check how it worked before they wrecked it. Pieta has the parts. Also send Mike. Send Mike the gun manuals from Pieta if he does not have them. Carrie, I think the easiest and most efficient way to approach this would be if Frank could get there and observe the testing. I fucking hate this email so much. No wonder they miscommunicated. That communication is so unclear. What do you need? So you're asking for your expert to be at the testing because he wants to see all of these things happen, I guess? Jason, I'm not sure it will be possible for your expert to be present for my expert's testing, as I'm sure it will be done over the course of several days. However, your expert can test the gun himself at a later date after reviewing the testing from Mr. Hagg. I will forward this information on to Hagg so he is aware of the concerns. That is a kinder response than I anticipated. My response would be like, can you please rephrase? Because that email is really difficult to parse. Okay, thanks. That will work. Great. Okay, this is probably the trial testimony. Oh, good. The notes are still in it. Here's a note. If people do not clear their notes in Google Docs, even when they upload their documents to the court websites, those notes still show up. We have found some very interesting notations on motions because people didn't clear their notes. So this looks like testimony from Mr. Bowles cross-examining Mr. Hagg because the state is arguing that Mr. Hagg did not perjure himself. Mr. Bowles, okay, sir. And with regard to your conclusion, I want to make sure I was clear on that. And I know that you, and I don't want to use the word critical, but you don't think that aggressive testing by the FBI was a good idea. Oh, were the emails voice to texted? Maybe. Mr. Hagg, I don't think it was necessary in this case, given the context and what the issues in the case, and what are the issues in the case. Mr. Bowles, okay. Hagg, in my mind, it was never an issue that the hammer got struck by anything or that the gun got dropped. Mr. Bowles, and so you don't believe that the FBI even needed to do that test? Mr. Hagg, from my viewpoint, no. Well, we know that the reason the FBI did the test is because of what Baldwin said on George Stephanopoulos' interview. Mr. Bowles said, okay. Mr. Hagg said it was not useful or necessary test to strike the hammer of a fully cocked evidence gun. Mr. Bowles, and these are Carrie Morrissey's highlights. So fantastic. We knew that because it's highlighted, but still just clear them. Mr. Bowles, did you also say that you did not find any damage to the weapon that would have prevented it from firing as designed? So now we are very, very narrowly parsing the question because Bowles asserted that Hagg perjured himself and that Carrie allowed that to happen. So she's saying, no, you ask a specific question, you get a specific answer. And Hagg never said that the damage stopped the gun from firing in any of the reports, including the report the defense didn't have, even though the defense didn't have the report. Bowles, did you also say that you did not find any damage to the weapon that would have prevented it from firing as designed? And I'm talking about not after the FBI, but prior. Is that your conclusion? Okay, well, that seems consistent with the report. What do you think? Mr. Hagg, yes, if the hammer were replaced and the trigger replaced and the bolt, it was a perfectly functioning, authentic replica of a classic firearm. Mr. Bowles, okay, sir. And in your inspection of that weapon, that Baldwin revolver, did you see any modifications that would have changed the firing characteristics of the weapon? That's pretty consistent. Mariella says, AI says everyone is reacting to how work emails get color coded. Yeah, I still don't know how that happens, but I love them. I love them. Absolutely. So, Mr. Bowles, okay, sir. And in your inspection of that weapon, the Baldwin revolver, did you see any modifications that would have changed the firing characteristics of the weapon? He's not asking if you saw any modifications. He's saying modifications that change the firing. That's consistent. No, not at all. In fact, I went through, I think there are 12 other revolvers. 9 of them are Pietas, and I took them all apart with the help of my younger son, Mike. And we looked at the sears, the triggers, the full cock notches, and they were all equivalent. You could have swapped them out because they carefully manufacture parts. That's how I addressed and answered the question in my own mind. Mr. Bowles, okay, sir. So other than the FBI testing, breaking those components, you didn't see any other evidence of modification or damage. Mr. Hag, I did not. So I think it leaves room to say in the Hag report, he said, look, I observed these, but I think that they came from the FBI testing. But that is, that's not necessarily what is on the second report, which is where this kind of becomes an issue. But the prosecution's arguing, look, he didn't perjure himself, and the defense says that he did. Bull says, okay, sir, with regard to the rounds that you were talking about, the Starline brass, and then it moves on. And that is the end of the state's response. So here's where we're at. And if there are still Olympic spoilers in the chat, Music to My Soul said, can we stop with the Olympic spoilers? The news app notifications are bad enough. And I had asked earlier, and I'm sure people have popped in and want to celebrate. I appreciate it. I have my phone off because I very much want to watch some of these sports today. So I have my notifications off. So thank you, chat. I appreciate it. I know y'all are excited. We can talk on Thursday about what happened today, but I wanted to stream for y'all. I didn't want to just cancel streams this week. I wanted to cover these cases, but I also want to see what's going on in the Olympics. So thank you for that. And thank you, mods, for that. And I know people are excited. And we will chat about it. I will put up posts, and we will celebrate sport later, because I do want to watch this. I do want to watch them, and sometimes it's just not as fun when you know what the outcome is. I mean, Titanic the movie, you kind of know what the outcome is, but you want to see the story and how you get there, like the historical fiction of it all. The Olympics a little bit different. So thank you, and I appreciate it. And there's lots of those of you in the chat that can't watch until later. So I appreciate it. All right. So thank you. And a good reminder. Sarah said, wait, you knew the Titanic outcome? So my friends and I were in line to see Titanic because Leonardo DiCaprio. And as we are in line to see Titanic, we are talking about the fact that we are very interested to see what the storyline is and how captivating the movie is when you know at the end, like the boat sinks. And there were people in line that were just like, what? And we're like, wait, what? And they're like, you can't talk about the ending of the movie, blah, 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 blah. And we're like, I mean, we haven't seen the movie, just like history and stuff. Like, isn't it well known that that's what happened? So as my friends and I are in line for the movie, the people in line behind us for the movie are like, what are you talking about? And we're like, we kind of want to see. I don't think we knew the word historical fiction, but I'm like, I mean, we're standing here in the what year did Titanic come out? We're standing here, what? Tony B said Titanic sank in 1912. Right. We're standing here and we're like, no, we're interested to see what happens in the movie when we know what happens with the ship. Like, the movie's like a countdown to the ship sinking. It came out in 1997. Thank you. So we're like standing there going, but the ship sinks. No idea what the plot is. Haven't seen the movie. There's a Celine Dion song and Leonardo DiCaprio's in it. That's all we know. But like, we know the ship, like, what? How are we confused? People were so mad. They were so mad that we talk about the ship sinking. And I'm like, okay, this is interesting. It was like being at a Dave Matthews show, one of like 2 shows where he covered Sweet Caroline, and the folks sitting behind us are like, is this a new song? And my friend and I can't even turn my neck because my neck's not working. The way we slow turned and looked them in the face and went, what? And they're like, is this a new song? And we're like, you're asking me if Sweet Caroline is a new Dave Matthews song? I don't understand the question. So every now and then we are caught off guard by when we think people know a thing and they don't know a thing. But you got to ask questions, I guess, to learn answers. And no, it is not. It is a cover. Good Lord. Music to My Soul said, Emily, to clarify, I'm fine with people discussing Olympic results from the 1910s. Yes, if we want to talk about the Olympic results of the first ever men's water polo match in like 1902, go right ahead. All right, let us continue on. So here's where we're at the end of all of this. Carrie Morrissey, in the snarkier than was called for response, threw Baldwin under the bus, tried to throw Bowles under the bus, tried to defend herself, admitted that the second expert report was not turned over to the defense, argued that the request for Hannah Gutierrez's release is premature, that there are multiple motions about that pending, that the motion for new trial needs to be determined first, then the motion for release can be determined, and that the motion for new trial isn't even ready for hearing yet because the briefing is not done. So she's arguing that the defense's motion for immediate release is not well taken because the briefing needs to be finished on the motion for new trial, and that is not complete, and that the state will be responding to that on July 31st. So we will be talking about the motion for new trial when the state responds. We've already talked about some of it because there's the motion for immediate release and the motion for new trial, and the defense has kind of put them all together, and the state is trying to parse them back out and saying the release is too early, but then also kind of arguing the motion for new trial, saying that the defense didn't really have anything that was missing, and even if they did, it wasn't impactful to their case because the Hague report was clarified by the third report, and the line of questioning at trial was not outside of what was in those reports, and it was consistent with what was in those reports. So the defense really wouldn't have done anything differently, and it wouldn't have impacted this trial, even if they had had that second report. But Carrie Morrissey is still responding to all these motions because she is still on the Hannah Gutierrez case as it wanders through the trial level court on the motion for new trial. Well, the second motion for new trial, the first one was on that jury instruction, and on what Carrie Morrissey says is the third motion for Hannah's release. The court is going to have to sort all of that out, and we will be there for what will invariably be a very spicy hearing when this goes to hearing. So, chat, are you ready to talk Tik Tok Psychic and then do Q&A? Are we ready? Are we ready to do that? I think so. I'm ready to do that. Let's do it. Let's do that. I need to switch out and then if we have time, we will go back to any of the emails, but we're going to go with our sound as it works for us. So we're going to go to Tik Tok Psychic motions. And again, remind people why representing yourself is always difficult. And that's what it is. Let's do a quick road so far, shall we? The Tik Tok Psychic defamation case at a federal court in Idaho has been ongoing for well over a year now. Recently, the court recently the court decided on the motion for summary judgment, and the court determined that the Tik Tok Psychic is in fact liable for defamation. So dealing with a civil case, we are dealing with liability for an issue, not guilt versus not guilt. Like, are you liable for the thing? Are you responsible for the thing? Are you not? Did you do the thing? Did you not do the thing? And is the thing you did, in fact, in violation of the law? The court found that the Tik Tok Psychic was liable on that motion for summary judgment. So the question of did you defame someone is done. The answer is yes. Now the case is moving forward to a potential trial on the question of damages, and the court allowed punitive damages to be added. Remember, those are the punishment ones. Like, what are you doing? You suck. Don't do this again. Those damages. They allow a jury to say, this behavior is unacceptable to us, and here's the amount of money to remind you that this behavior is unacceptable. So that is the procedural posture of the case at the moment. However, the Tik Tok Psychic then went, yeah, no, we're not doing this. I want a new judge. I want this judge reassigned. And if this judge doesn't get reassigned off this case because they're clearly biased against me, and the Tik Tok Psychic argued in that motion that the court is violating her right to religious freedom by saying that there is no evidence that the things that she stated about a University of Idaho professor killing 4 students off campus, the case that Brian Koberger is being prosecuted for, is against her religion because her tarot cards told her that that was the truth, and requiring her to have independent verifiable evidence of the things that she said is somehow impeding her right to her religion. So she is asking that the court be removed, that a new judge be assigned, and in the alternative, that the court reassess their ruling on the motion for summary judgment. She actually said, I am giving the court an opportunity to rectify its ruling. So that is what's going on with the Tik Tok Psychic. She filed those 3 motions, 2 motions to yeet the judge, 1 motion for reconsideration wherein she tried to relitigate the entirety of the thing. The professor responded because the professor has to respond because this litigation will not stop. And of course, the TikToker is representing themselves. So all of these motions are being filed by her. This case is far from over. The fight over religious freedom is something that is just not well placed in this case because it's just not well placed in this case. But that fervent circular arguing in this case is got to be incredibly difficult for the lawyers to parse. It's hard for me to parse every time we read it. And it's been difficult for the judge to deal with. I've listened in on the hearings in this case, and the judge tries to redirect the TikToker to make the arguments in a linear way that need to be made. And it is just so incredibly circular, and all of the arguments keep circling back. And some of them are arguments that have to be addressed, including at one point, the TikToker arguing, well, if you say that my religious practices are not founded in evidence, then aren't you saying their opinion, and opinion can't be hearsay? So it's that kind of circular arguing that the court and counsel have been dealing with, probably at great expense to the university professor, who sent a cease and desist and said, can you please stop calling me a murderer? And then we're on the call for the last motion, and the TikTok Psychic is saying to the court, well, you can't just take her word for it. She's a murderer. That was her argument to the court, y'all. So we are deep down the rabbit hole of this case. And when this case was first filed, many of you asked, and a lot of you probably still feel, isn't there anything the court can do to look at this case and say, fuck no, we're not doing this, and throw it out? No, there is a, sorry, I got distracted by Olympic spoilers. You guys, come on. The court was dealing with sorry, I am so distracted. Chat, I will be back. I'm going to have to put the chat off for just a minute so I can finish this. Cause we have asked a couple times for no spoilers and I appreciate it. We're trying to get through the filings, but I'm going to have to pause for me, my chat real quick. So thank you. All right. So a lot of you have asked, and I'm sure many of you feel like the court should be able to just look at this and be like, yeet immediately. Like, why can't we just immediately get rid of this case? But there are processes and procedures for this that are required. So you can't just look at this and look at the case and just hurl it. Especially because the plaintiff is the one seeking a remedy here, who is the harmed party, the university professor. So for all of you asking, what about vexatious litigation? It's not because the university professor is trying to rectify a wrong done to them. So it's not vexatious. It's trying to rectify the wrong. And you can't just look at it and be like, well, obviously this is defamation. What are we even doing here? Stop it and enjoin someone's speech. So there is process to all of this, which is tons of litigation. And so with that litigation, you have potentially a year plus of having to pay to represent your reputation, really. And then go through this case. And so for the professor, I feel so incredibly frustrated going through this case, which is why I won't stop going through this case. And in going through it, I'm sitting there going, she is going to spend 2 years, 2 years plus going through this litigation to maybe get to trial. And if she gets to trial, then she will win potentially damages and potentially win a injunction to enjoin the Tik Tok Psychic from saying the things that she has asserted against the professor. That is a remedy that can't be got until the end of all of this. We saw it in like the Cardi B case, where you can get at the end of it an injunction saying you cannot say these things. It is a difficult remedy to get. It is a hard remedy to get, because enjoining someone's right to free speech is difficult. But when it's been found that they have defamed someone, you can narrowly tailor what can and can't be said in some type of permanent injunction. But even then, that's continued litigation. And even if you win an amount of monies, that's continued litigation. And then if the other party files for bankruptcy or whatever, that's continued litigation. So the plaintiff in this case, the professor, is on this for like a 5-year run of potential litigation to try to get somebody to stop lying about them. And that is part of what can be really frustrating looking at the civil system, is because what do you even do? And so when somebody chooses to sue like this, they have to sit down with their attorney and be like, okay, what is the end game here and how long are we doing this? It's just really, really, really tough. And so I feel for the professor in this, which is why I keep covering this case, because it's just really difficult. A couple of you asked, what about a gag order? A gag order only stops things during the case, but it's not going to stop things after the case. So not being able to talk about the case, they aren't really talking about it that much. So not being able to talk about the case doesn't get you a permanent remedy or permanent injunction. Normally money damages is enough to kind of rectify the behavior. But when you have someone who might not pay those money damages and might not be able to, then what remedy is there? So it's really frustrating. And I feel for this professor. So we are going to keep going over this case. There are 3 responses here from the TikToker we're going to go over all 3 of them and then we'll get to Q&A. But it's a frustrating process, especially when you look at it and you're like, there's not a question. To me, there's not a question here. This is accusing someone directly of a crime. It is accusing somebody of a crime repeatedly. When they say that there is no evidence of this, even when the police had to make a statement saying that there's no evidence of this, it still did not stop. It's incredibly frustrating to watch. So let us get to this. So, all right. Let's see. This is the defendant representing themselves response to, normally it goes right there. Right in this box is where we should see it, but no, we don't. So defendant Ashley Gouliard's reply to plaintiff's response to motion for reassignment to a district judge. So she's asking again, to have, this is her reply to the opposition to her motion for a new judge and to be reassigned. She's already consented to this judge. She's already said that this judge can oversee the case. And this is so late in the game. You can't yeet the judge because you don't like their ruling. That's not grounds for yeeting the judge. So she's saying, in accordance with provisions, District of Idaho General Order and General Order number 324, defendant requests that the reference of the case to the magistrate judge be vacated and the reassignment of the case to a district judge be supported. Again, she already consented to this. She already consented to this judge's jurisdiction and the rest of it. Reference of civil matters to magistrate jurisdiction is contingent on the consent of all parties. This voluntary consent may be vacated specifically pursuant to the district court. And this is how she's saying it should be vacated. She is saying, if a party wishes to file requests for reassignment, you will file your request in paper form. You can send it to the court by mail or may email the email address. Upon receipt of your request for reassignment, your case will be reassigned to a United States district judge. A request for reassignment will be entered in the docket. However, no document is attached. The docket text will not include who filed the request, so the confidentiality of the filing party remains. This is the process when the case is first assigned, like very first assigned. So this is not the process for after rulings. This is the process for the beginning. Footnote 1, a link to the website. They say that she followed the directions of the court by emailing the provided form and request for reassignment. The motion process for reassignment does not align with the court's stated procedure, nor does it align with the other rules that she has cited. First, the motion was filed within the document, with the document attached exposing that she had requested the reassignment. Next, the motion allows for her voluntary withdrawal of consent to proceed before the magistrate. Both actions violate the provisions of the code. The willful misinterpretation is ongoing and unyielding, and that's not. It's not the time has passed. And timing in law is quite important, but the timing has passed. The timing is well past. And the law cited by the lawyers in the opposition is accurate. So this is not going to fly, but the judge is still going to have to do a very thorough written order on it, like everything in this case. Relevant background: on November 13th, 2022, four University of Idaho students were murdered at the request of a TikTok user. She conducted a spiritual investigation consisted of tarot readings, oracle readings, and public information to determine the motive and causes of their deaths. She has started putting this in every motion that, like, someone asked me to do it. Someone asked me to do it. Someone asked me to do it. So, you know, with someone asking me to do it, that makes it okay. No, it doesn't. They go on. The lawyer goes on to say that her spiritual investigation revealed that the plaintiff ordered their murders and executed it with the help of a male student. She reported the information she received to the relevant FBI tip line. The FBI! And reported her findings on TikTok. She keeps narrowing down the language of how she did things, but she went on social media well before she ever went to the tip line. And just going to the tip line probably wouldn't have landed us here, right? On December 21st, 2022, the professor filed a lawsuit against the TikToker for defamation. The case was assigned to the judge. All parties consented to magistrate jurisdiction. That's a key part. All parties consented. They sure did. All parties consented to the magistrate jurisdiction during the litigation of the case. The TikToker continuously expressed her concerns with the violation of her constitutional right to a fair trial and judicial impartiality due to the judge's inability to be impartial, exemplified by his continuous mocking and ill statements about her spiritual beliefs and practicing. This judge has been more patient than any human I have ever seen in a robe. The amount of patience executed by this federal judge has been admirable. And the judge has not mocked anything. See docket 50 in the motion hearing held April 16th. TikTokers' concerns were denied and ignored. Right, because you didn't show that the judge was impartial. Despite plaintiff's complete failure to meet all of the required, let's see. The judge, I skipped a sentence, I apologize. On June 6th, the judge granted the partial motion for summary judgment, despite, she says, plaintiff's complete failure to meet all the required elements for defamation. That's not what the ruling says. The judge made false statements about TikToker in the order. This is a bold strategy. Made several manifest errors of law. What? And made statements that are outside of his jurisdiction and legal authority. TikToker requested to reassign the case to a district judge and filed a motion to alter and amend the judgment. A Squeaky Bean makes a great point in the chat and says, I don't know, Judge Darrow was pretty patient. The issue I took with Judge Darrow was that Judge Darrow would get pulled into the circular arguing games and start arguing back instead of redirecting. This is wild. Tell me again what the judge's manifest errors of law were. Good Lord. Legal standard. TikToker's request to vacate the magistrate jurisdiction is supported by 28 U.S.C. 636 and Federal Rules of Civil Procedure 73B, District of Idaho General Order 237, General Order number 324, and District of Idaho Local Rules. You can't make new argument in your reply. Like you can't make new argument in your reply. The defendant's request is not quote unquote gamesmanship. Instead, the reassignment request is to prevent the continuous violation of her constitutional right to fair and impartial judicial proceeding, to prevent an unnecessary appeal to the United States Court of Appeals for the Ninth Circuit, and to prevent the continuously violation of judicial authority and jurisdictional boundaries. Therefore, the defendant's reassignment request meets the extraordinary circumstance. It does not. It does not. Argument. As mentioned in the opening statement, TikToker followed the directions provided by the court, and then cites to the same website, to request reassignment of the district judge. Okay, but that's when the case is first assigned, though, not after substantial proceedings have happened. She also used the document provided by the court to request reassignment. As a pro se litigant, the court is a trusted source of information and direction. The court can't give you direction. The court can't give you direction. That's not the court's job. So, you know, TikToker emailed the request to the email address. The court did not follow its own directions by attaching the request for reassignment document to the docket, ergo exposing TikToker as the party who made the request. Okay. These procedures that she's citing are the procedures for the inception of the case, not for this far into the case. So that's why the court did that. Also, everyone knows you're the party that made that request because the other party replied to the motion and didn't make the request. The plaintiff's argument in subsections B and C of docket 80 fail because the court, based on the instructions and the court provided form, did not request justification at this stage of the reassignment process. You are willfully misunderstanding what stage of the proceedings you are in. You should ask your lawyer about the proper process, and docket 80 that we've covered should give you a hint as to where we're at. Additionally, the plaintiff's argument in subsection C of docket 80 fails because TikToker is not alleging the judge has been unfair altogether. Instead, she argues that the judge's bias is based on a lack of ability to be impartial regarding the plausibility of her spiritual beliefs and practices. The judge made specific statements demeaning the defendant's spiritual beliefs and practices, calling them arguably so baseless, delusional, fanciful, lacking common sense, and implausibility. There's more context to that. It goes on to say that the judge's bias is the basis of many of his decisions to include his interference with her discovery attempt, with TikToker's discovery attempt. She goes on to say the judge went beyond his constituted, does she mean constitutional? Constituted authority, alleging in an order that the professor is not guilty or was not involved in the murder of the 4 University of Idaho students, and alleging that Koberger is guilty before his opportunity for trial. That's not what happened at all. She goes on to say the judge made several, she's just relitigating in her reply instead of actually replying. She's saying the judge made several critical legal errors to include granting the motion for a summary judgment without meeting the basic elements of a defamation claim. False. Not to mention the judge rendered judgments when the court lacks jurisdiction. Based on the aforementioned, the defendant requests the reassignment. That's not going to happen. And she's saying it meets extraordinary circumstances. The only reason you need to meet extraordinary circumstances is because the case is so far along. So all of the forms that were filled out and all of that procedure is for the very inception of the case before anything's been heard. Conclusion, the court should correct any errors to the instructions and procedures for request for reassignment to the judge, refer the motion to a district judge, grant the motion for reassignment to a district judge, and correct all errors made by the judge. No, that's not what's going to happen. And the court isn't making errors here. Okay. So that is response number 1 to the defendant's reply to plaintiff's response to the motion for reassignment. But don't worry, there's more. There is a second reply because the TikToker didn't get the response they wanted and just filed it twice. So there's a second reply because the plaintiff said she did this twice. And so if we need to reply, she did it twice. So here's us replying because she did it twice. So here's our response. This is the defendant's reply to docket 83. Docket 81 is a duplicate of Docket 75. Defendant did not intend to file a second motion to reassign the case. Defendant mailed in a copy of the request for reassignment to follow the instructions on the form to the extent that it is required that she incorporates by reference the last reply, and asks the court to grant the first motion. So this was a just kidding whoops, which is kind of what we knew, that it would be a just kidding whoops. But still. The big reply is going to be this next one, and this is the reply to her motion to amend the judgment. This motion was extensive, and the TikToker tried to relitigate literally fucking everything. So this is the response to that. The professor responded with, you can't relitigate everything, and there's no grounds, like legal grounds, for the judge to just like not grant the motion for summary judgment or to reassess. And she said in her motion, the TikToker said in her motion, she was giving the court an opportunity to correct their errors. So I'm very curious what opportunities the court will be given in this motion. So defendant TikToker's reply to plaintiff's response to defendant's motion to alter or amend the judgment. Defendant brought a motion. Let's see. Defendant TikToker's motion to alter or amend the court's order granting partial summary judgment and allowing plaintiff to amend the complaint to add punitive damages is meritorious and supported by Federal Rules of Civil Procedure 59. The plaintiff's opposition to the motion is an attempt to continue to obstruct and compromise justice for her selfish gain. That's where we're at. That's where we're at. We have not just doubled down. There isn't even doubling down. This is just quadrupling down on the no, screw them. The amount of energy responding to this type of argument takes is wild. Background. We've already gone through the background. It's the exact copy and paste from the last background. Legal standard. Okay. TikToker's Rule 59E motion meets the legal standard as established by Venti versus Xerox Corporation. Where's the rest of that citation? Because I want to pull that citation. I don't see the rest of the cite in the motion. Though that's not the way you, okay. Emily, let it go. You're not a legal writing professor. That's not the way you cite that. Just FYI. Let's see. Gouliard's motion, TikToker's motion, shows more than a mere disagreement with the court's decision. I disagree. Instead, it's clear that the court completely ignored the defamation standard established by Idaho Jury Instruction 4.82. You need to cite the law, though. And went beyond its constituted authority and jurisdiction and allowed personal religious beliefs and bias to interfere with TikToker's constitutional right to an impartial tribunal. As a result, the court under magistrate tutelage made several manifest errors of law, manifest errors of fact, and caused manifest injustice to TikToker's detriment. Argue that's not the legal standard, though. You didn't. That's argument. You didn't cite the legal standard, though. Where? Anika, thank you for finding the proper case citation. I'm now fascinated. Argument. First, regarding plaintiff's argument A. These aren't plaintiff's arguments, though. This is your reply. It's your motion. Okay. First, regarding plaintiff's argument A, TikToker's motion is not procedurally improper. A Rule 59E motion must be filed no later than 28 days after the entry of the judgment, giving the court the opportunity to immediately correct its own mistakes. Well, we're not at a judgment, though. Rule 59E and Rule 60 does not require the judgment be final. Second, regarding plaintiff's argument B, TikToker's argument goes beyond mere disagreement. Additionally, the plaintiff has not yet to provide any evidence that TikToker made false statements. Oh, here we go. This is when we get into the Daryl Brooksification of the whole thing. Is it always circles back to plaintiff hasn't proved that she's not a murderer. This is just a sticking point that this particular defendant is not going to move on from. Not ever going to move on from. She is stuck here and she is not going to move off of, you didn't prove that you're not a murderer. So until you prove you're not a murderer, her argument, until you prove you're not a murderer, what I said is not defamatory. She goes on to say, plaintiff has not yet proved any evidence that TikToker made false statements and that she knew the statements were false. Instead, plaintiff sought to use the civil proceedings to manipulate the civil court into determining that she is not guilty for murder of the 4 students. That's not what happened. Instead of litigating the elements of the defamation claims against defendant, the court focused on finding Schofield not guilty of murder. I don't even know how you get to that interpretation. Again, going beyond its authority and completely ignoring the proper application of the Idaho defamation laws, the plaintiff also focused on arguing that she is not guilty of murdering the 4 students instead of proving her defamation claims against Gouliard. Third, regarding plaintiff's argument C, the court lacks jurisdiction of the murder of the 4 students. Therefore, the court does not have the authority to determine Schofield's innocence or guilt of the murder. Okay. Fourth, regarding plaintiff's argument D, the plaintiff has not suffered any damages. Damages are going to be determined at trial. It is beyond a legal certainty that Schofield has not suffered any damages because she did not suffer reputational harm, did not suffer job loss or loss of wages, and that she has not provided any evidence of severe mental distress. I find this to just be a willful misreading of what was argued, of the ruling, and of the law, because the court is finding a lot of this under defamation per se, and you don't have to prove damages for defamation per se, and the court granted the motion as to liability only, so damages is going to be forthcoming, but for the defamation per se, which is what we've got here, you don't have to prove damages to get to liability. So as to liability, that's been determined. Also, I think there was ample evidence of the filings of severe mental distress. It goes on to say, instead, the plaintiff argued that her damages consisted of the voluntary purchase of an alarm system worth $400 and over-the-counter sleeping aids. She has not provided, they say, any evidence supporting her claim for damages to date. It is clear beyond a legal certainty that diversity jurisdiction is improper because plaintiff has not suffered $75,000 in damages. The complaint must be dismissed. We are post-summary judgment. We are post-summary judgment. A motion to dismiss is not timely. A motion to dismiss is not well taken. A motion to dismiss is... No. 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 No, no. No. The complaint must be dismissed. No, that's not how any of this works. Ask your lawyer. Fifth, as stated more fully in docket 77 and 84, the court violated TikToker's right to an impartial tribunal and discriminated against her based on her spiritual practices and beliefs. It is evidenced by the court's continuous mocking of her spiritual beliefs, referring to her spiritual beliefs as baseless, implausible, lacking common sense, fanciful, and more. The court was quoting law, but okay. Additionally, the The court did not say that about her beliefs. The court was talking about the standard. Additionally, the court falsely claimed that TikToker admitted to defamation. The transcript of the hearing proves that Gutierrez specifically said no when the court asked. Is the transcript in docket 73? Because I didn't see a transcript in docket 73. I'm going to have to look for that real quick because I absolutely want to, I don't think that was in docket 73. We're going to go look. Hold on. Give me 30 seconds. Nope. We're going to pull up docket 73 real quick. I'm going to try to pull up docket 73 real quick and see if it's in there because I don't remember there being a full transcript in that docket item. So give me a moment while we pull it up together, and then I think I have it in my file as well. So I'm going to look two places real quick. Thanks, chat. We're going to look together because I was on that call and the court was saying, can you understand how, given all of this, it could, if not true, be defamatory? There was much conversation in there, but I didn't see the transcript being filed. Oh, and it's because it's not in here. Let's see. Transcript of the hearing, docket 73. Docket 73 is not the transcript. Docket 73 is the minute order of the hearing, but not the transcript of the hearing. So that is different, and it is not there. All right. I had to be clear because the writing was not clear, and I was like, wait, did I miss it? No, I did not. The transcript of the hearing proves that TikToker specifically said no when the court asked. The court blatantly ignored Idaho Rule 6-1604, again discriminating against Gutierrez for her spiritual beliefs and practices by allowing for punitive damages to be added to the complaint. Again, the court didn't say you can't read tarot. The court didn't say you can't believe anything. The court said what you can't do is defame people. So you can believe what you want. It's the accusing people of things that's the thing. So instead, the court erroneously ruled that TikToker's faith and belief in her spiritual practices and its messages amounted to malice. The not stopping was the thing, not the belief, not the practices. It was the actions really that are the problem here. Punitive damages in this case is improper and an impediment to justice. I don't think the plaintiff sees it that way. Lastly, the defendant's statements are privileged against defamation claims due to qualified privilege and absolute privilege. No. There's no TikToker privilege. There's no absolute privilege for you. There's no qualified privilege for you. None of the things that you said on TikTok are privileged. She's saying they are protected by qualified and absolute privilege because they were made in an attempt to help solve the murder of 4 students during judicial proceedings and preparation. You weren't asked by the FBI or anyone else. You weren't asked. You weren't asked by law enforcement to help. You are not a witness. You are not a detective. You are not part of law enforcement. And because you are not part of law enforcement, you are not covered by privilege of doing your job. You were not asked. You did not report this to a tip line. You did not make a report to police. You went on TikTok. That is not the same. Statements made on TikTok are not privileged. You're also not covered by litigation privilege, which is not what you've cited here, but you're not covered by litigation privilege either because they weren't statements made during litigation in the litigative process. And don't even start to think that going on Twitter or TikTok or YouTube or social media or wherever and saying shit just because law is pending protects you either. That's not how it works. It's not how it works. It's not how it works. And you guys all have great questions. I'm holding them to Q&A about how this goes on. We're going to talk about it. That's not how this works. These arguments have already been completely discounted by the court, but still. Conclusion. Defendant TikToker's motion is meritorious and exceeds the high burden of reconsideration. No. It's in the best interest of justice for the reassignment of this case to a district judge and to alter the judgment, and to render the entire litigation void and dismiss the complaint with prejudice and punish the plaintiff and her counsel with sanctions due to the filing of the frivolous complaint. No. 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 That's not going to happen. That's not how any of this works. And the complaint's not frivolous. The complaint doesn't meet the definition of frivolous. You're not going to punish the plaintiff and legal counsel, and the court has been restrained in not issuing sanctions against this pro per defendant. That's not what's going to happen here. Just because you convince yourself that you are right does not mean you are right, and a federal court is going to tell you that you are not right. This is not how that works. And this is not what's in the interest of justice. None of this would have happened if she had taken the cease and desist and went, okay. But she didn't. So there is no privilege here. The court's not going to assign it to a different judge. The court's not going to amend any of this. This is going to move towards trial. This is going to go to trial on damages only. She has been found liable for defamation, and that's not going to go away. But the court has not yet set a date for this, so we don't have a hearing date yet. These though were just filed on the 18th of July, so we've got a little time to go before a hearing date gets set, but there is no hearing date set yet for these motions. It is just a continued relitigation of all of the same things. It is like Darrell Brooks. It is just okay, but even though we're here, we are going to circle back to the same arguments in an effort to exhaust the court. And maybe if you ask this time, they'll say yes. That's not going to happen. And this is not going to be over soon. This case was filed in December of 2022. This is not going to go to trial on damages until sometime in 2025 at the earliest. So this is going to be years of litigation paid for by the professor. The TikToker has to pay to file their motions, but they can also get fee waivers because they're representing themselves. So they are really only spending their time to do this because they are not paying for an attorney. So the court time and the plaintiff time are what's being paid for here. But again, the court can't just yeet this out of existence because the plaintiff has a right to bring a lawsuit for defamation. It's just incredibly, incredibly frustrating. So with all of that, what's the best summary of this? And in response to all of the plaintiff's oppositions to the motions to reassign the judge and the motion to reconsider the summary judgment, the TikToker has again tried to relitigate every aspect of this, accusing the court of being biased against her spiritual beliefs and practices, accusing the court of gross misstatements and misapplication of the law, and continuing to relitigate the same issues ad nauseum, including the assertion that everything she said on TikTok is covered by qualified and absolute privilege because, quote, it was in an effort to solve these murders. However, the privilege that attaches to law enforcement, prosecutors, judges, and others does not attach to individuals saying shit on social media. The individuals saying shit on social media, if they are wrong, can be sued for defamation, and that is why we are here with the TikToker being sued for defamation in a case that's not going to go away quickly or quietly. Because I imagine that at some point we are going to see some intervening appeals filed if the lawyer for the pro per determines that they are going to try to do that. I'm not saying that that's appropriate at this time or can even be done, but I'm saying that I think that we will see a ramping up of this litigation, which will, again, be costly to the professor who just, it seems, wanted the TikToker to stop accusing her of being a murderer, which the TikToker has doubled down on in all of these filings and in the court hearings. But when this goes to hearing again, I will keep you posted because, look, as defamation suits go, they are often not very cut and dry. And we have covered a few that are difficult. And where is the line of opinion? And where are the boundaries of that? This is not that case. And we are going to cover it anyway, because I think it's an example of how extensive these litigations can get, even when at the beginning you look at this case on its face and go, yeah, you're right. That is defamation. But that isn't how it goes in court. So we are still here, even though this case was filed in December of 2022. Absolutely frustrating to watch. But look, we saw pro per defendants like Darrell Brooks in real time in court, and we are watching the kind of written process of that until this goes to trial. It is equally frustrating. And with that, you've got questions, I've got questions, we've got questions. It's been a day. So let's just do the things. So as we get to questions in our part 2 stream, no, Nightbot, I wasn't trying to pull up your comment. Kate Wooden in the chat said the professor needs to catch a break super soon. She did with the ruling on that summary judgment. I think it was the proper ruling, so I'm not saying that it was like a break. It was an incredibly favorable ruling that was warranted. Discovery had closed. The TikToker put nothing forward to prove that there was any factual basis for the statements that she was making and for the accusations she was making. So that is a huge ruling because it cuts off all trial on liability. So it's just done as to liability. So it only goes forward as to damages. But because we keep getting all of this, it's just a lot. And it's going to be a lot for the professor. So Steeler with RSD said the real murder trial will be over before this case. It might be, but that trial is not set until summer 2025. And it's going to be what? I think the court set aside 3 months for it, June to August. So that's going to be a 3-month long trial in June. And with that, we've also got motions coming up this month on that. They're on the docket. We're working on getting a docket into the app, but the upcoming Koberger motions in August, I will be covering because there is ongoing litigation with regard to the motion for change of venue. Some of that is sealed, some of that is not sealed, and we will get through that as the state's motion comes in. We'll do both. We'll do the defense motion and the state's motion together. And that's still ongoing. But that hearing will happen at the end of August. So let's see. Let me let you guys know what. I'll just give you a brief rundown of what we've got coming up real quick. I'm not going to get all the way in depth because this will change. So note, this is subject to change. Subject to change. Let me see. But I want to pull up the date real quick. So we've got, of course, that Karen Reed hearing is coming up on August 9th. I'm going to be covering that hearing live. We've got stuff coming up in the Corey Richins case. We will probably go over some of those motions next week. I have to decide if we're going to do Food Court on Thursday or if I'm just going to tap out and watch the Olympics on Thursday. I don't know. I'll keep you guys posted on what we're going to do for Thursday. But we've got some motions to cover in Corey Richins, and that's getting ready to go to preliminary hearing. That preliminary hearing will be at the end of the month, and I will cover that streamed. So that will be really interesting. That's like a 3 or 4 day preliminary hearing. The hearing in Idaho, that big change of venue hearing, is at the very end of August. So that last week of August, we're going to be really busy, and we're going to cover all of those. And then when we get the Hannah Gutierrez hearing, we'll see that. The trial date is still moving forward on Donna Adelson, so we will keep an eye on that as well. So we've got a lot on the docket. We've got a lot of court hearings coming up, but I don't think we will be covering a trial until we get to the Adelson trial in September, just because of how busy August is going to be and how busy August is family-wise. So that's what we are going to do. And then we'll see how we go. We'll see how we go trial-wise. So that's what we are taking a look at. So let's see. Space Cat said, I saw Logan Paul's lawsuit prime drink yesterday at the store. The flavor looks meh. I haven't seen the flavor, and we will absolutely see. We will absolutely see what happens with that. I mean, he's going to have to pay money. So money will have to be paid, and we will see. Rainbow 910 says, I feel like I'm still recovering from Karen Reed and barely remember Baldwin. Karen Reed was a really long trial. Baldwin was quite a lot, but it was fast, but it was quite a lot. And covering trials takes quite a lot of time, and then catching up on cases takes a lot of time. Inertia said Sarah Boone trial. I don't even know when that's going to go to trial now that she's representing herself. I'm keeping an eye on it, but that's been pending for 4 years. So I don't have any thought of that going to trial soon. Sharon said, I love the app notifications. Thank you. We are working on the app notifications, and we appreciate it. Honk Banana No says, if you build your own streaming backend, please call it Milkshake and use it to bring all the boys to the yard. We are working on things. Michael, thank you for the gifted memberships in this stream and in the other stream. I appreciate it. Laura said, RIP to all your past videos praising StreamYard. Look, the thing that's so frustrating with StreamYard is it was the best solution on the market, and it got sold out from under the founders of the company to a new company. The new company has made absolutely no effort to maintain the customer service. I don't know how much effort they've made to maintain the product because they're not really responsive to questions and concerns when it is not working. And I have no idea what the new company plans to do with it. It is very frustrating. And so everybody who uses StreamYard is just kind of in the dark. They didn't even really announce the sale. It was announced all in trades, but it wasn't really discussed. And then the founders stepping away from it was based on stuff they posted. So it's really frustrating. So I'm sad. It worked great. And so I stand by what I said at the time that I said it. It just has shifted, and that's frustrating and well outside of my control. Just well outside of my control. Kayla, thank you. Everyone appreciates a good angle. Music to My Soul said, in my humble opinion, all this snark will only show to the judge that Carrie has learned nothing from the sanction in the Baldwin case. She won't get the benefit of the doubt on any violations found in this case. I think it's a real bad look, the amount of snark. Really, really, really. J. Michael said, would the result in overturning her conviction instead of a retrial, there's still a Brady violation. The violation is unlikely to result in the overturning of her conviction. Could it result in a new trial? Even that's going to be tough for Hannah. I'm interested to see all of the motion work on that, but it's not going to be nearly as clear cut. Rachel Mills asked, can we cover R. Kelly on Thursday? I don't know what's going on in R. Kelly, so I can't tell you one way or the other because I haven't seen anything new at all. So Kathy Adaw asking about the Tik Tok Psychic. How does the judge or the judicial make this stop? Kathy, the judge granted the motion for summary judgment and has to keep going through the court process. So how does the judge make it stop? By going through the entire process, going to trial on damages, enforcing the damages if they are not paid, if they are awarded, potentially awarding a permanent injunction, enforcing that injunction. But there's not much that can be done except continuing to go through the process. These Are My Monkey says, why isn't this an abuse of the court system? The TikTokers responding to being sued, and they are right. They are allowed to respond to being sued. So this is them responding to being sued. And so they didn't bring the case. And there's not a lot of room to sanction them because they are a pro per. So it's tough. Laura M asked, is she even collectible? I doubt much. I really doubt much. Mom wants tacos. I mean, vibe always. EDB, since this is a waste of taxpayer money, can the state step in at some point if this keeps going? No, the state doesn't have any standing here, and the taxpayer money, I don't see it being wasted in the Tik Tok Psychic case because the professor is the one who is bringing the lawsuit. So I think the professor is in the right spot to bring the lawsuit. Like, what else do you do? I really don't know what else you do if you're the professor other than bring a lawsuit. So it's frustrating the way that the TikToker is proceeding through this litigation, but the case has to move forward because the TikToker wouldn't stop independently of bringing litigation. These motions that the TikToker is bringing are going to get ruled on by the court. Motion practice is part of practice. At some point, could the judge sanction the TikToker for bringing motions without standing? Possibly. I don't know if that's going to happen, though. Like, I just don't know. Miss C said, I just got my offer accepted to buy a house. I'm so excited and nervous. Congratulations. Read all the paperwork. Keep all the paperwork. You've got it. Debbie I says, who pays the court costs for all of this? The TikToker pays for theirs. The professor pays for theirs. And then the court system is the court system. So that. Steeler with RSD asked, the judge is making Sarah Boone represent herself or pay for a lawyer. Can the judge make TikToker get a public defender? No. This is a civil case. You don't have a right to counsel. You don't have a constitutional right to counsel. TikToker could hire a lawyer, but there's not much a lawyer can do for her at this point. It really bothers me she can do this to the professor. There's not much that the court can do at this point. Casey Katz had a contribution to your Olympic sporty sport viewing adult beverage fund. Thank you. I appreciate it. Mira, we're going to go over the Koberger filings. I mean, lately it's just been sealing stuff, but when we have a state's response, we will go over them together on that motion for change of venue. We'll go over those together because that's going to be a full day in and of itself. And I want to go through the filing and the state's response at the same time. Brandon said your adult beverage fund to help keep your Olympic watching experience enjoyable. Thank you. We will get back to it. Ann Bell says, I need a quick bit explanation of water polo. I tried to watch a few matches and couldn't follow anything. It looked like a bunch of people chasing a ball in a pool. I mean, essentially it's a bunch of people chasing a ball in a pool. There's goals on either side, and the setup is kind of like basketball. In the way that you run plays, you've got like a outer arc at the top and a lower arc at the bottom. And so the plays run kind of like basketball plays do. People drive through the center and what have you. And then you score on the goal, and the most goals win is the most basic. But yes, it's a bunch of people chasing a ball in a pool. It's just hard to see because if you don't know what you're looking at, you really only get heads above the water some of the time, and the action moves very fast. And what I found difficult with the coverage in water polo is that the camera operators don't always know water polo well. And so sometimes the camera operators move from where the ball's going oddly. So the coverage can be a little difficult to watch because they don't always follow it smoothly. And what else? There's a lot that happens under the water. One whistle, little foul, two whistles, big foul. And when people get kicked out to the corner, when you get put in the penalty box like ice hockey, then you have man up plays. And that's generally when a lot of the scoring happens. And the goalies can't touch the bottom, even though they get out of the water like past their belly button. That's all based on their leg strength because they're incredibly strong. And that is called egg beater. That is generally at the international rules, very little from the US rules. And a lot of the international players also play in US colleges. So there's that. Kelly Kell said, my boss threw a brief and an MTD at me at 8 p.m. It's so rude. The profession does it all the time. Like the legal profession has no boundaries for time, but it's really, 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 really frustrating. I Love Pie said, wait, they can't touch the bottom. Oh no, those pools, I mean, most pools are 10 feet deep, some are 12, but no, they cannot. So no, they cannot. It's fun. So it's got the basketball, soccer plays are kind of the same thing, but no, they are swimming or treading water the entire time unless they're ejected and then they're hanging on the lane lines in the penalty box. So no touching the bottom. No touching the bottom. My expert is better than yours. Use mine. That's kind of what Bowles was trying to say. He's like, my expert's great. Oh, Sweetie No said Bowles was an assistant U.S. attorney from May 96 to February 01. That's a much longer time than I expected. That's wild to me. Ice Baby said, no lie, this happened when I went to see Romeo and Juliet in the 90s. I apparently ruined it for others. What? Also, Leonardo DiCaprio, solid movie. Really, really enjoy the Baz Luhrmann Romeo and Juliet. And also, it can't be a spoiler if it's based on Shakespeare. We know what happens. You don't go to see what happens. You go to see how they tell you what happens. Christina said neck pain twin just got home from 9-hour med clinic and watching with a heating pad. Can't turn my neck at all. Kept leaning on the wall to prevent sudden movement. Is this what 30 looks like? I mean, it is not delightful. And we're going to be working on some appointments to see if we can figure it out because it keeps happening. So Tina said, for your fun fund, I have had a chaotic month, bought a house and moved to a new house a week after moving my business. That's a lot. Then my stepdad died last week. Tina, I'm so sorry for your loss. And I sold the old house. You keep me grounded during it all. That is a wild month, Tina. Hang in there. And you are managing it all. And just accept when you're exhausted that you have to rest because it will get done. It will get done. You've got it. So it's a lot though. Casey Cass said, EDB, you made me think TikToker focused on that particular professor. So scary how it could have happened to anyone. The TikToker talked about it in their motions. They talked about it in their motions. I don't know. They talked about it in past motions, but it was basically going to the history department's website after being guided, they say, to the history department. So Barba Fett said Tati was talking about a possible settlement on the Halo case. Can we get updates? I have been on my list to pull court documents. So yes, I have not pulled court documents on the Tati case. They are getting ready for trial. Trial is going to be what? Hundreds of thousands of dollars. It's a lot. And again, Tati's in the same situation, arguing with a party that doesn't seem to have much interest in resolution. When the other side's only interested in winning, everybody loses. Law has to be about resolving. So when people don't come into it with that goal, it can be very expensive and tedious. Misconduct. Misconduct was funky and fun, or fun and funky said this case blows my mind. It's really a tough case because it's so frustrating. Just frustrating. So Christina also mentioned how Jason Bowles was a New Mexico U.S. assistant DA. So if he was an ADA, I wonder how much he went to trial for 4 years and 10 months, according to LinkedIn. I wonder if he's run into Kerry before. I would imagine there is a good possibility. But it also depends on what area he worked in the U.S. Attorney's Office. Christine D said, I put my tumbler on my coffee warmer, ADHD. Will there be a new one anytime soon? We are working on updates to merch. And I don't want to give you a timeline because I don't remember it off the top of my head. And I don't want to be wrong and have people being like, but I was waiting. So do not worry. We have things, but if you need to replace it, they are in the shop. And if you reach out, let us know. And, but if you need to replace it, there are some of the oil slick ones left in the Lawnard shop. I love this one. I love the all black one too. I don't know if there's any of those left, but I know that there's some of the oil slick ones left. Stephanie said, happy 41st birthday. I need to pull up some of the chats from the other stream that, technology yeeted. So from Agorkin77, lots of sevens. Do we know where the live rounds came from? The prosecution has continued to argue that Hannah brought them onto set, and I think that has become more probable that she got them from her dad and they got mixed in, and that's how they got onto set, and she didn't check them clearly. So that's what the prosecution's theory is of where the rounds came from. Net Cirque 84 said Phantom Regiment was my favorite Friday. Phantom! They were great. Look, Bluecoats were also great. They were. Blue Devils were great. It was a good show. I enjoyed the Cavaliers show. Their props didn't make a ton of sense to me, but I liked their music. The Bluecoats sounded amazing. When you're talking like wall of sound amazing. Ray in the chat said, do we need to all send emails to StreamYard? No, that ship has sailed. Like the ship has just sailed. So no, we're moving to other things. So yeah, no, I think it has sailed. Let's see. Christine said car accident. Boo. Emily streaming. Yay. I'm sorry for the car accident. I hope you recover well. Music to My Soul said, me choosing to be here instead of streaming the U.S. Women's Gymnastics Olympic team final live proves my deep love for you, Emily. Music to My Soul. Thank you. It's why I was getting salty about spoilers too, because I know so many of you chose to be here, and I don't want you guys to get spoilers in the chat either. Ashley McQuirk in the chat said same thing. EDB versus Team USA Gymnastics is a Sophie's choice. I know. So Christina Melanik said, speaking of water polo, I was today years old when I found out they're swimming the entire time thanks to a TikTok of a girl finding out in real time. The whole time. I forget that people don't know that. It's wild. Mujer asked about the coffee cup. It is from the Year of the Dragon from Starbucks. I don't know if those are still available, but that's what it was from. Ohio Palm Mom said equestrian events at the Palace of Versailles. It was so cool to watch. The set, look, I'm from LA. I get it. But LA is not going to have the grandeur that Paris has had as an Olympic city. It has been just unparalleled. Some of the vistas and scenes you get. I don't know what they're going to do. Like, where are they going to house everybody? Are they just going to put them at the colleges like they did last time? Like over at UCLA and USC? What's traffic going to be like? Like LA can't get people back and forth in a reasonable amount of time anyway. I'm nervous. I am nervous for all of the Angelinos. Let's see. We've got a few more questions. Well, we've got a bunch more. Let's see. Cartaluna said there's an update on the baby reindeer case. We're going to get to baby reindeer. I'm optimistic this week. Let's see. I vote for a name 'em hoodie. I'd wear it every day. I will. It's not my catchphrase, so it's tough. I'm sure that Sutton has made one, and then I have seen a lot of you ask about Mr. Beast. Don't worry, we'll get there in a second. Questions. J. Michael, again, thank you for the gift of memberships on stream 1 and stream 2. Jordan said, not really watching the Olympics, but I did watch Deadpool Wolverine. It was fantastic. I definitely want to see it. And we will see. Aurora said, could I ask for the laundered magic? We found the perfect house the other day and we need all the magic so I can chat with you from a dream office. Aurora, we have had lots of good house karma in the chat. So there you go. Let's see. Tinkle Tits McGee said, Peacock is trash. I'm mad about their coverage. The Peacock coverage has not been super easy to navigate. I agree with you. So it's not been the easiest. To navigate. And it's hard when they cut things into parts. It's just been like, stop it. I did not get the full screenshot of the new song with the paging Dr. Beat. It also sounds like paging Dr. B to me as well. And I've gotten a number of you DMing me that it sounds like it's paging Dr. B. Casey Haj said, Emily, I was diagnosed with ADHD last week and started meds for my spicy brain. I feel so much better already. You and the hubby helped me make it happen. Look, the more information you have, the better decisions you can make about what you want to do. So I always think having info is good. Slicey Slice said Jason Kelsey is the super fan for the women's rugby for the Olympics. I'm waiting to see Jason Kelsey and like Flavor Flav start fighting it out for like who's the biggest super fan, and they're all going to lose to Snoop. Snoop has taken over the Olympics. It's Snoop's Olympics now. You know, the man, I'm sure never even imagined when he was in the middle of like 90s rap beef. And we'll talk about Keefe D because that case is still moving forward towards trial for the murder of Tupac. It's on track for November. We'll see what happens. But, you know, when he's in the middle of like, and the Tupac case is wild. But when you look at everybody's whose names came up and you look at like Snoop's involvement with gangs in Long Beach and, you know, outside of Compton and the record labels he was a part of, the fact that he kept himself out of so much shit is pretty incredible because his name doesn't come up in any of this, but it's those record labels that are still involved in all of this. It's just absolutely wild to me how he was able to navigate such a violent part of gang history in Los Angeles and not end up in prison. I think Martha Stewart went to prison longer than Snoop's ever been in custody. He was never in any of this shit. It's just wild to kind of see the side quest of Snoop's life, becoming friends with Martha Stewart, making wine, making food, coaching football, and being such a positive influence. It's absolutely just it's incredible to see. And you watch, I don't know, I love watching it. It's like you never know where somebody's life's going to take you, and then you watch it and you're like, that, wow, okay, I'm here for it. Like, I'm here for all of it. I'm here for the love. I'm here for I'm here for all of it. So it's just wild. And his kids show, yes, and his positive Griffin. You scared me. The positive affirmation music, just all of it. You scared me, buddy. What's up? I'm still streaming. Hi.
Sorry to interrupt.
Thank you, buddy. It's just, again, it's kind of fantastic. Thank you, buddy. So I've loved watching it. I love that Snoop is just like, this is what we're gonna do. And now like we're the official mascot of the US in the Olympics, and it's great because, you know, who doesn't love Snoop? So, let's see what else. New Hampshire asked if I'm going to be following Sarah Boone in October. I don't know if it's actually going to go to trial in October. We will see. So Candace asked if my video of the Alec Baldwin dismissal is still available. Yeah, it's up on the channel. And I think we also have some up on the Quick Bits. So it is there. A lot of you asked about the Mr. Beast stuff. I have not taken a deep dive into everything going on with Mr. Beast, with Ava Tyson and the rest of it. I know that there's a ton of stuff going on. I have seen the internet talking about it. I have not done a deep dive. I don't know if I can even help on really what could be potentially, like if we're looking at what's alleged as to Ava with distributing inappropriate images to minors, potentially soliciting images from minors and the rest of it, whether that could be criminal, I don't know enough about. What's going on with Mr. Beast and what he knew and what he could have known, and if there could be lawsuits there. I just don't know enough to kind of parse those two trajectories and talk about it. If that's something you guys do want to talk about, we can talk about it probably on a members only. It's just what is going on with the what is going on with people who have audiences on YouTube talking to minors. It is a very, very disturbing situation. Red member said there's also a Mr. Beast, Rosanna Pansino stuff going on about his Prime show. New stuff? Because there was other stuff. So I'll have to go look about new stuff. Over Newman said, how about YouTube appearing to censor content creators covering the Mr. Beast issue? And I would need to look at that too. Because one of the things that's a problem is if talking about Mr. Beast is connected to inappropriate conversations with minors, inappropriate images of minors, if those two topics are connected, then there can be issues that aren't always connected. It's like when stuff was going on with James Charles, that a lot of those videos were getting suppressed, and it's not that they're suppressed about James Charles, it's because the content that they're being suppressed. So it's tough. It's tough. AR said, wait, Mr. Beast was talking to kids. There's no evidence of that, but one of Mr. Beast's right hands, and my understanding is one of Mr. Beast's like old childhood friends, who was also part of his team, seemed to be using his position at or with Mr. Beast to open the doors to inappropriate conversations. And yeah, I've seen a ton of conversation about it, but I don't know enough to tell you if there is potentiality for criminality there. I don't know. The statutes of limitations on things like soliciting images from minors or showing images to minors tend to be quite long. So that can be something that can be pursued, but it's wild to see because it's the ongoing pattern that we're seeing with content creators, particularly having this stuff bubble up on Discord, on Snapchat, those are the biggest platforms, DMs on Twitter and stuff like that. It's really wild, but it's also making sure that when you are a parent and you're looking at what your kids are doing on a Discord, on Snapchat or what have you, that you never, ever know who your kids are talking to or what those conversations are. So it seems like there's multiple things going on. There is stuff going on with Ava and messages and Discord leaks and conversations and that stuff's going on. But then it seems that Mr. Beast also, from what you guys are saying, has stuff going on with the Prime show, which is a whole separate issue. Prime being Amazon Prime, because Mr. Beast announced that he's doing like a game show for Amazon Prime that I think is filming now. So there are two separate issues and a lot is going on. But I think the conversation is when you have a kiddo that is engaging on social, know who they're talking to, have open conversations with them, have open conversations about boundaries, about what's not okay to ask, about not sending pictures, all of it. Just having real uncomfortable sometimes conversations with their kiddo. The earlier you start those conversations, the less uncomfortable they are. But it's really also empowering kids to have the conversation with you and to trust you to have those conversations when they feel like their boundaries are pushed, because the stuff that is coming out is a pattern that we've seen play out in other areas too. It's been a lot. Casey Cat brings up the Colleen Ballinger situation. That I haven't seen that it's still ongoing. I also don't understand the power trip of wanting to expose children to sexually inappropriate conversations, content, photos, ask them for photos, talk to them about it. No, do not. Also, adult creators shouldn't be in discords with their young fans. It's completely inappropriate. No, not okay. Shouldn't be happening at all. Also, I love my 12-year-old. I love my 16-year-old. I don't understand, other than either creepiness or a complete power trip or a combination of both, why anybody wants to be in a Discord with a bunch of 13-year-olds. Like, what in the world? But it is an issue. Michelle said you need a red live light outside your door. Oh, I have one. I have one. So, yeah. My daughter in middle school keeps asking me how she can just be a kid. It's right. It's hard. And it's especially when you have people like Mr. Beast's channel is one of the biggest channels on the platform, if not now the most subscribed to channel on the platform. The content is very much appealing to kids, young kids. And when you see things like him opening Beast Burger, it's 9-year-olds that are asking their parents to get Beast Burger. My 16-year-old could give a shit. It is younger kids that are into it. He just launched a bunch of toys as well. So there's just a lot of room for influence to override people's better judgment. And that happens with parents too. And we've seen it kind of across different things. If we were talking about the Olympics, we've seen it in the US gymnastics abuse, that even the parents were kind of overridden by the predator in that case. And so it's something that parents have to be aware of, that kids need to know their boundaries of, and what people shouldn't be asking them. It's so tough, and it's sad. And we've seen it with Colleen Ballinger recently, Dr. Disrespect, Ava, Tyson, James Charles, and others. So it is, the way I look at all of this is a access and fame problem. And when you have people who are famous in the online sense, being in a Discord gets normalized. Being in DMs gets normalized in a way that's very different than like a more traditional celebrity who's a movie star, right? When we were growing up, we were joking about Leonardo DiCaprio movies earlier. When we were growing up, there wasn't like join a Discord server with an actor that you saw in a movie. Celebrity wasn't the way that it is now. So when you're looking at the accessibility of online creators, it's a huge issue, because that barrier to access is much lower, and we have seen numerous people take advantage of it. People will continue to take advantage of it. It is inappropriate. It is unacceptable. We will see what YouTube does, if anything, because again, Ava is not on Mr. Beast channel, Mr. Beast put out a statement that she'd been fired. So Ava's no longer part of Mr. Beast channel, but what happens from here, we'll see. It's just really tough. And then the similarities we saw with, and this was from a Twitter thread. So apologies if it is not all verified, but the Twitter thread and videos I saw were individuals talking about working in the Discord server as minors, and that's how they ended up in the Discord server, which is very much what Colleen was doing as well, is having minors who were excited to have access to a creator that they loved, and then that creator also having them do free work to kind of bring them into that environment. And then the environment was an inappropriate, unacceptable environment, allowing people access to minors that they shouldn't have had access to. It's just wild, but it is something that parents have to talk to their kids about, and that creators should not be doing at all. Because I don't, why? Just why? Also, don't have a Discord with kids in it. Like, why is that hard? It's just, I don't, just not okay at all. Not unique by any means to the internet, but different to the internet, right? That barrier of access is lower. So I don't have any more really on the Mr. B stuff other than loosely seeing it all over social media. I've really just been wanting to like run away and watch people play water polo and deal with my neck hurting. But it is it's a tough thing, and it's truly sad to see for me to see just over and over and over and over again the draw of being a social media personality being leveraged to have access that shouldn't be had, to do things that shouldn't be done. Just sad and frustrating. And I think the first solution is helping kids understand what appropriate boundaries are, I think is the first thing. And it's hard because the people who are preying on kids shouldn't be doing it at all. Shouldn't be doing it. But how do you help kids understand where those red flags are, right? And how to notice that red flag behavior, because they also have to have that information so that they know it's not their fault, but they have to also be empowered, because it's hard to stop people doing the things that they're doing. And I don't know the answer to that yet. I mean, it gets called out when it's caught, but how long do the things go on before they get caught? And then even when people, I mean, we saw it with the Colleen Ballinger situation, which I'm much more familiar with because Adam McIntyre talked about it so openly. But even when he initially talked about it, he was completely attacked and not believed. And then it took time for everybody to come back around and be like, wait a second. So it's tough. And the solution is, should people be having these conversations with children and be in Discord servers with them? Absolutely not. But the conversations still need to happen too, so people can hopefully spot the red flags. And so that parents, I think the reason it needs to be discussed is why parents need to know that these things happen, because I don't think everybody knows that this stuff happens and that this stuff can happen. And it's really, really hard stuff to find if no one says anything. And that's what people rely on, is that it's hard to find. And that's one of the things that's so difficult about sussing it out and rectifying it. So it's really, really difficult And there, again, it's frustrating to see. Just really, really frustrating to see. I really hope that we're at the end of it. I don't think that we are by any means, but it makes me sad. So for parents, should people be engaging in these conversations with your kids? No, but can you engage in these conversations with your kids? Yes, absolutely can. Absolutely can. Because truly kids don't know, and it's tough, and people know that, and they use that, and it's very hard. It's very hard to suss out. So it's frustrating. I'm frustrated by it. And again, I just wanted to run away and watch water polo in the Olympics. But every time I open up YouTube, that's all I see in the headlines. And I haven't gone through many videos on it. But I don't think we're done. So that is part of it. And Pam A said stranger danger, not just in the streets. It's part of why we have to keep having the conversations about it. And I guess if there's anything to come from the fact that these are conversations that are being held and had around the internet, these are the conversations that hopefully help parents be aware, help kids be aware, and help people start pushing forward to things getting actually done about it. So we'll see what happens. But without a much deeper dive into it, I can't give you a plus minus on, if there's criminal stuff. If there were pics sent to kids is criminal. Soliciting pics from kids is criminal. So if those things are happening and they're proven, that can be a thing. And then what happens with, being an employee for Mr. Beast? I'm sure something Mr. Beast is going to be talking to his lawyers about of what, if any, potential civil liability there could be there. So we will see. What I will say is in the States, especially for crimes that involve victims that are minors, the statute of limitations have continued to change and continued to extend much longer, with the acknowledgement that it takes victims sometimes quite a while to even know that they were victims because of the nature of the crimes. So the statute of limitations have changed. And I think that is a part of starting to fix, or starting to at least hold people responsible, as those statute of limitations have shifted. And then I think the open conversation helps as well. But it's tough. Julie made an excellent point. Say people still deny the friend family dangers despite the spotlight of the internet. Honestly, the bigger danger truly is the bigger danger truly in a lot of cases are people who have access that are in somebody's life and have access, not just somebody on the internet doing something. And those are conversations that need to continue to be had, right? So it's tough and it's sad, and there's been a lot of stories popping up of people using their influence online for inappropriate and abhorrent behavior. So we will see where it goes from there. But that was a long way around of, I don't know if I'm going to dive into that anymore. So I don't know. I just don't know if there's any need, unless anything comes up legally, and then maybe we will. So maybe, I don't know. There's a lot of a rabbit hole there. I'm sure there's plenty of people diving down it, but I really do stay a lot away from kid victims. And so if there's lawsuits, might we reevaluate? Maybe. I really don't want to dive into everything that's going on. Because A, I've had to do it enough in my past work life, and B, it's quite a lot. I would really like to get back to food court. I tend to stay away from the child victim cases for a lot of reasons for me, but also for you. So I think going over the conversation is important. Continue to have conversations, and with those conversations, it's okay to use stories like this to have conversations with your kids. To be like, hey, did you hear about this? Hey, what do you think about this? These things coming up in the media and being discussed can give an opening to have those conversations and help, those in your life know more. It's like when topics come up about having a family password, because people can use voice recognition to pretend they are your family member, pretend they are your bank or whatever, or use your voice to call your bank to give your security answers and stuff. Room to have conversations. So lots of room to have conversations. And I think we learn through conversation. Conversation is powerful. Using stories in the media to open the door to conversation is necessary sometimes. So I'm really more here for like the Logan Paul and CoffeeZilla stuff, because at the end of the day, we'll see what happens, and we'll see what comes of it, but it's not nearly as heavy. Like Logan Paul being big mad that CoffeeZilla called his crypto game a scam is not nearly as impactful as people abusing their positions of fame and power to engage with children inappropriately. So, well, more crypto scams. Is that where we're at with more crypto scams? Is that where we're at? Maybe more crypto scams. That's not the takeaway. Food court. We've got some food court. We've got some music court. We've got stuff that's coming up with, Idaho, when the prosecution returns. We've got a lot of hearings coming up in August. So we need to do that. So with all of it, that's Gothboy UK said we need a little more fluff. We've had a lot of heavy. We have had a lot of heavy. J.A. Williams said, isn't it a slippery slope when discussing child issues between informing parents and informing predators? The only reason, J.A., I don't see it that way is because of my previous work life. There is lots of discussion and lots of forms that help inform predators. So our conversations here are so far below those conversations that are happening. We started to see some of it in the discovery in the Josh Duggar case about the children images and about which file sets might be flagged by law enforcement, conversations about which Tor browser to use, how to set those things up. Those conversations are happening. They're just happening in places that most of us don't see on the internet, but the conversations amongst people looking for those things are going on. So nothing we talk about is really going to inform that, because of the cases that we cover and the work that I have done. So it is happening. It is happening. So look, conversation, that's where we're going to get to with all of it. I don't know if we want to dive into the stuff more unless there is more to cover. But I will take a look at whether the topics look like they're being suppressed on YouTube. That I'm interested to see. And I wonder if it's the correlation between the two topics. because when you have a topic involving minors and that topic gets connected to names, we'll see. That I'm very interested in. So, let's see. X Glitter Diva XO said, sorry to hear about the neck. Thank you. May I suggest alternating between warm and cold? We have been doing warm and cold. They work wonders. I have a severe crack a few months ago. Made one for heating and 2 for the freezer. Thank you. Yes. And, have been, I am no stranger to orthopedic injuries. It's just an ongoing situation, which is why I should probably wrap up. Tamagen, we are working on it. And yes, there will be. So yes, we will be. Oh, Amber AQ82 said, remember Snoop Dogg pins. Yes, that is what we needed to wrap on. So this is what I wanted to talk. Thank you, Amber, for dragging us back into the, dragging us back into something else. Let's see. I'm going to see if I can find a non-video, because I've got legal questions about this too, in a half joking, but also my lawyer brain has made it the worst kind of a way. But let's see. Where is this? I am grabbing this from, let's see. Oh, no, that is, here, we'll grab this one. Let's see. So we have talked about the fact that some at the Olympic Village, some at the Olympic Village trade pins. I am fascinated by pin trading, but I also saw a Instagram reel, because I don't TikTok. I saw an Instagram reel that completely called me out, that was like, do you really want the thing? Or is the dopamine of trying to find the thing like feeding your ADHD? And I'm like, fuck, that's me. I don't know if I want the thing. I just want to find the thing. Damn it. I love the scavenger hunt of it all. So me in so many contexts of my life. Do I love a good pin trading moment? Yes. Do I love an exclusive thing? Yes. Do I love trying to find an exclusive thing? Yes. 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 It's so me. The finding of the hard thing. Ugh, I love it. So when I saw, and I've seen in the past discussion of Olympic pin trading, again, this Olympics feels different just because of where social media is. Plus the pandemic Olympics wasn't nearly as social as this Olympics has been. So it feels like we get more of a behind the scenes, and I love it. So I have been following anyone who will talk about pin trading at the Olympic Village and discussing that each country has its own pins, and a lot of them are customized by sport, but some athletes have their own custom pins, including Simone Biles. Absolutely love it. Love hearing about it. Love seeing it. Learned today years old. And when I say I'm covering the Olympics in my stories, all of it, today years old when I learned that Snoop has his own custom Olympic pin. And for those of you, hold on. For those of you that missed part 1, don't worry, it'll be up in a little bit. We're going to take the tech issues out and then put it back up. I need a picture of the Olympic torch to illustrate my point. We talked about the Olympic torch in Paris, and the fact that I think it looks like a gigantic blunt. And you're not going to convince me otherwise that Paris doesn't have a sense of humor with this Olympic torch. So this is what I'm talking about with the Olympic torch. Look, you're not going to convince me. Look, it just is what it is. It just is what it is. I don't know. It's not just because Snoop Dogg's holding it either. Come on. This is the actual pin, or this is the actual Olympic torch. This is 100% the Olympic torch. Like, stop it. This is what they chose. It's not photoshopped. This is the Olympic torch. So when I was giggling at the beginning of this about that, I also knew, because I saw it this morning on social, that Snoop Dogg has his own custom pins for the Olympics, which as a commentator is unprecedented, but he's Snoop motherfucking D-O-double-G. So he gets to do just whatever the fuck he wants in my book at this point. So Snoop has his own custom pin. I thought it was for athletes. He's a commentator. I don't care at all. Don't care at all. Have no idea if the weed is legal in Paris. Don't know. I'm sure some of you can tell me. No clue. But oh wait, now we've got to go to Snoop's custom pin at the Olympics that was shared by Coco. Is it Guff, the tennis player? This is the custom pin a la Snoop. This is his custom pin in Paris. So, I don't know if the Olympics have approved this use of the Olympic rings, but I also think there's room for an argument that these are not, in fact, Olympic rings. I think the color of the rings is probably proprietary, but I also don't know if the Olympics can do much about it. So, I don't know if Snoop's pin is approved or official. I don't care. Look, Coco shared this on social like a fucking legend, so thank you. The way that I would be look at the detail on his shirt. The way that I would be focused on this. I don't know how athletes can focus. How do you still focus? Like, you've got to just be done. I think rugby's done today. I need everyone to just start pin hunting. Can we just? So I'm not the only one, clearly, who thought the torch looked like a blunt. Snoop Dogg has made his own custom Olympics pin for trading. I absolutely love it. I think it is the best. So all of this is just hilarious to me, and I'm here for it. Simone Biles also has custom pins. And then different sports have custom pins. And I think the Simone, let me see if I can find a picture of it. The Simone Biles one is like a heart with her signature in it. And I think she's one of the few athletes that has a custom pin. But of course, people are so excited to see Simone Biles. So why wouldn't she have a custom pin? I love it. So Simone has a custom pin. My favorite picture coming out of the Olympics, I think, has been Simone Biles with Shaq. It was so good. It was just so good. Okay, here is a picture of the Simone Biles custom pin and how I imagine the athletes in the village are just looking for Simone Biles to get the custom pin. And I love them so much. Oh, she posted it on her stories. So that's how everybody knew. I didn't know this. This is coming from the Daily Mail, but it's the first picture I saw of it. So we are going to share that because Olympic pin trading is so much happier than awful things happening on the internet. So this is from Simone Biles's Instagram stories, custom special edition pins, and they are hearts with her signature in them that she took to the Olympics to trade. So there are those who have gotten the pins from Simone Biles to pin trade at the Olympics, because Olympic pin trading is a whole it's a whole sport in and of itself. I don't know who gets the gold in Olympic pin trading, but I'm going to need to see everybody's lanyards at the end of this because it's so funny. Like, it's so funny. I saw some of you saying, no offense, not as cool as Snoop. Look, Simone Biles can't put smoke rings on her pin. Everybody's going to want a custom pin, but it's so cute. It's just so cute. And it's gold. I just love it. So I have no idea when the pin trading started. I know this has been going on since, at least the 90s, but it's so good. Like, the Olympic pin trading is such a thing. And if you rabbit hole on the internet about Olympic pin trading, you will see people sharing their lanyards from years and years past of the Olympic pins. I think it's a fantastic way for people to have a conversation with people who do, other sports, people from other countries. I just think it's a great moment of community. And I love it. So Lawnards, I see all you asking, will we do Lawnard pins at some point? At some point, not an Olympic one. That's for sure. We're definitely not doing that. But I have been meaning to do pins when I go to things so I can give them to you guys. So there will be pins. Do not worry. But I love the Olympic pin trading. I'm going to keep sharing my favorite behind the scenes of the Olympics on my Instagram stories. That's where that's been living, because it's a easy and quick place for me to share it for you guys that are interested. And then for you that are like, miss me with all of it, you can just ignore my stories until closing ceremonies and it'll be fine. I will keep you guys posted in the Law Nerd app what we are doing for the rest of the week. We've got some cases and some stuff. And I also want to make sure that I don't have to make you guys pick between everything that's going on in the world and everything that's going on in the law. So I will keep you posted. Members, for those of you that are asking, there is no podcast this week. This is a week that I've been trying to rest and recover. So there is no podcast this week. So you haven't missed it. Do not worry. We are not doing a podcast tomorrow. We are in a slower recovery week. So with all of it, thank you for being here. Thank you for being Law Nerds. We got to break down all the what's the what going on in Rust. It's not going to be over anytime soon, but I'm really interested. I'm really interested for that hearing. Really interested. So with all of that, you guys have a great rest of your Tuesday. I will too. Team Baker and our mods and members, thank you. It is, we are working on the tech, and I will keep you posted on what we're going to do with that. But at least stream number 2 went a little more tech smoothly, and yay for that. So yay tech. But you guys, I will see you soon. And, have the app. I'll keep you posted on when we're streaming next. Bye. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.